on 16th of September.
Heard Mr. S. Baker, the learned counsel for the appellant, who prays for an adjournment. On what ground?
Lordship,
On what ground?
Senior counsel B Dutta has
On
personal
on the ground of personal difficulty of the conducting counsel for the appellant. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to his prayer. Hence, the prayer is allowed. Let this appeal be listed for admission on 16th of September.
Me, please, my lord. My lord, item number 25, I'm appearing for respondent number 1 and 2, my lord. Would you consent I beg to mention item number 25, my lord?
What is your prayer? What do you want to mention?
The adjournment, my lord, for 2 weeks, my lord.
What is your name?
N. Upadhyay, my lord.
Heard Miss N. Upadhyay. You are appearing for?
Respondent number 1 and 2.
Appearing for respondent number 1 and 2, who prays for an adjournment. She submits that she has informed learned counsel for the appellant. What is your name? What is your name? Miss K. Verma, the learned counsel for the appellant, does not raise any objection to the prayer. Stop. Hence, same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Grateful, madam.
May it please, your lordship. Sir, I beg to mention item number 49 on behalf of Mr. G. Boisto, my lord. His mother is expired, my lord. Item 49.
An adjournment prayer is made on behalf of Mr. G. Bosho on the ground that on behalf of Mr. G. Bosho, the learned counsel for the appellant on the ground that he is in bereavement. Considering the ground stated by learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks.
Its date may be fixed, but this is a first time, my lord.
Okay. 18th of September.
Much of lordship, similar prayer, lordship, regarding item number 1, lordship. Lordship, senior counsel Mr. Rishi Sama today is not well, lordship. Matter will come on after first week of September, lordship, any date.
Item number 1. What is your name?
Be the lordship. I'm
Sir.
for the respondent.
Well, you have informed the
Lordship.
heard Mr. B. Dorloy,
Deudi, lordship.
B. Deori, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of senior counsel for the respondent number 5, 6, and 7. He submits that he has informed the learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed
First week of September, any date, lordship.
after 2 weeks on a date to be fixed by registry.
Lordship. They are the interim, lordship.
The interim date of the due, 3rd of September. The interim order shall continue till next day.
Yep.
Lordship, I would like to mention item number 28. Item number
28. 28. What is your name? M. Borkakoti. What is your prayer?
item may be adjourned.
You have informed the other side.
We have tried, but we cannot contact.
Then you wait for your turn. We will allow your prayer when the matter is called.
My lord, order matters, my lord. Let it be list for Friday. MSC will release it, MSC.
Court number 8. Senior court is there.
My lord, item number 52, today's date fixed for hearing. My lord, it was directed to appellant to submit a certified copy of the civil certificate. The same is not obtained, my lord. May it be fixed on 7th September. 52.
For the respondent, I'm not.
Heard Mr. B.R. Das, the learned counsel for the appellant, who prays for an adjournment on the ground that some documents have not yet been collected by the appellant. Mr. K.K. Day, the learned counsel for the respondent, Mr. V.K. Barua, the learned counsel for the respondent, does not raise any objection, hence the prayer is allowed. Let this matter be listed
7th September.
after 2 weeks on a date to be fixed by registry.
Highly appraised.
May it please your lordship, I'd like to mention item number 6 on behalf of the private respondent and for the petitioner, Your Honor. With the Your Honor. consent of the petitioner, Your Honor, in this matter, interim may be continued.
What is your name?
P. Chaudhary.
Heard Ms. P. Chaudhary, learned counsel for the respondent, who seeks an adjournment on the ground of personal difficulty. Also heard Ms.
TJ Sahewala.
T.J. Sahewala, the learned counsel for the petitioner, who does not raise any objection to the prayer. Hence the prayer is allowed.
Interim may be continued.
Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next day.
Highly obliged.
My lord, I'm trying for listing on RSA, your lordship.
What?
On RSA, your lordship. For listing.
RSA
First
not-
week of September. your lordship.
court number 8. Go to court number 8.
Obligation.
Pray for listing a MSc appealship for orders lordship.
MSc appeal also court number 8. EPS.
Your lordship, we have received the notice, but we were not served with the petition copy.
For respondent number 2,
Respondent number 2.
you serve him. Heard Mr. M.A. Sheikh, the learned counsel for the petitioner. Also heard Mr. What is your name?
Robin Kanti Tongchang.
N.
NK Tongchang.
N.K. Tongchangya, the learned counsel for respondent number 2, who submits that he has not received the copy of bail application. The learned counsel for the petitioner is directed to furnish copy of bail application along with annexures to the engaged counsel for the respondent number 2 during the course of the day. Let this matter be listed
On Friday, my lord. My lord, I'm in jail, my lord, for a long time.
8 September.
Obliged.
Orders, item 14.
My lord, in this case, it is ready regard service, my lord.
I'll court record and see. Mr. S.K. Ghosh, the learned.
Sir, the matter is otherwise very simple. If your lordship desires, it can also be perhaps disposed of.
Though I desire, but there are a lot of other cases in admission.
Can it be?
We'll fix a short date. S.K. Ghosh, learned counsel for the appellant. Also, Mr. N. Dr. learned senior counsel assisted by Ms. I. Das, the learned counsel for the respondent. This appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Can it be on a fixed date? Lord? it permits, the diary of the court, it permits
It
that.
will go after 2 months, 2 or 3 months, fixed date. Suggested it. Suggest 3rd of December.
3rd of December.
Yes. Let the matter be listed on 3rd of December.
Item 15.
Right.
His Lordship may kindly peruse office note dated 19/8/2026. Lordship, we have filed our affidavit for paper publication.
Okay. In respect of respondent number 7,
Lordship, I deeply apologize, Lordship, I don't have the file right now.
third Miss
K. Bora.
K. Bora, the learned counsel for the appellant. None has appeared for respondent number 1 to 6. Learned counsel for the appellant submits that in person to the directions of this court, the appellant has taken steps for the issuance of notice to respondent number 7 by substituted mode of publication of notice in the newspaper, and have also filed an affidavit in compliance thereto. Stop. I have gone through the affidavit filed by the appellant as well as the newspaper annexed therewith, in which the notice to respondent number 7 has been published. Stop. In view of the above, the notice issued to respondent number 7 is held to be duly served. Record, I say. Duly served. It appears that the records were not. It appears that the records of the trial court have not yet been received by the registry. Let a requisition be issued for calling records of the trial court. Registry shall take steps in this regard. Let this matter be listed again after receipt of the trial court records. After
Authorized.
after 3 weeks. After 3 weeks.
Obliged.
Item 16.
That page also. Also, this petition has been filed for continuation of delay of 220 days, Lordship, for filing, Lordship, on the review, petition, Lordship, against one, testamentary appeal, Lordship. Also, we have stated the ground, Lordship, that thing, the Lordship, petitioner was not informed, Lordship, about the, Lordship, disposal of the testamentary appeal.
You are opposing?
Opposing, Lordship.
What are the grounds?
Grounds, Lordship, the petitioners are not informed, Lordship, about the disposal of the case, Lordship. And Lordship, the petition was, testamentary appeal was disposed on 7/3/2019. Thereafter, Lordship, they were not informed, Lordship, the petitioner was not informed, Lordship. And then when they came to High Court, Lordship, for getting the information on 7/8/2019, on that day, Lordship, they came to know about the, Lordship, disposal of the testamentary appeal. Then on that day itself, Lordship, they have applied for certified copy and got the certified copy on the day
When
itself.
the order was passed?
Order was passed on 7/3/2019, Lordship.
When you came to know?
Came to know, Lordship, 7/8/2019, Lordship.
Thereafter?
Lordship, thereafter, Lordship, after receiving the certified copy of the order, Lordship, of the testamentary appeal, Lordship, handed over the copy and
When you applied for certified copy?
on the date of 7/8/2019, Lordship. on the same day, Lordship, when they have come to inquiry about the case, Lordship, to the High Court. And on the day itself, they have received the copy, Lordship, 7/8/2019. And if we calculate the date, Lordship, from the date of Lordship, passing on the judgment, Lordship, then 220 days, Lordship, and from the date of knowledge, Lordship, 69 days, Lordship, delay.
Who is the counsel?
Counsel,
Who was the
Lordship,
counsel?
counsel,
When you are imputing something against a counsel that he did not inform you, you have to name him.
No, not named, Lordship, here.
Then why this court will believe?
Lordship, thing is, Lordship, they are, Lordship, all are ladies, Lordship, poor people, Lordship, and residing in the village area of Gwalpara, Lordship.
No, but
All
you
are-
are alleging something against the counsel, that your engaged counsel did not inform you about the fate
No,
of.
Lordship, it's not, Lordship, but thing is that they, Lordship, did not contact, Lordship, during the proceeding, Lordship, and the advocate also not informed, Lordship. Then they failed to contact. And when they come to High Court, Lordship, for getting the information, Lordship, on the day itself, they came to know, Lordship, that the order was passed, Lordship, and or matter was discussed,
So you are saying that your counsel did not inform you.
Lordship.
So
And
you
they have
are
stated in the petition also.
shifting blame on the counsel.
Not blame, Lordship, but thing is that also they are residing in the village area of the Lordship Walpara district. They are all old ladies, Lordship. Around aged around 60, 58, like that, Lordship. And they are little knowledge about
On
the
what
laws.
ground you are seeking review?
Review, Lordship.
The appeal was dismissed,
Lordship. No, appeal was
allowed.
allowed, Lordship. The appeal was filed by them, Lordship.
Appeal was against which order? Why appeal was preferred?
Against the will, Lordship.
We,
was-
probate was granted or no?
Probate was not.
Probate was granted, Lordship. But Lordship, the ground of they approached the Honorable High Court, Lordship, in the testamentary appeal, Lordship, that the legatee was died during the proceeding of the Lordship, probate proceeding, Lordship.
They preferred the testamentary case. Lily Bosomotari,
Yes, sir.
Kunkumi Bosomotari, Anamika Brahma, and Kulu Brahma.
Lordship,
Appeal was dismissed.
appeal was dismissed.
Yes, what is?
They obtained the certified copies on 7/8/2019. And thereafter, as per paragraph 7, they have submitted those documents before the advocate on 16/8/2019. At paragraph 7, they have stated. On 16/8/2019 for filing the present application. And next, same line, the same was filed on 22/10/2019. But actually the appeal has been filed on, review has been filed on 15/11/2009.
On what ground you are seeking review?
Ground, Lordship,
But probably not that close. But because.
Do you have a good ground for seeking review?
see, there is a ground, Lordship, therefore, Lordship, we have.
But
filed-
you don't know the ground.
So actually, the today is fixed for the combination of delay, Lordship, therefore I.
No, but if you have very good ground, we may take a liberal view. But if you don't have a ground at all, we may not take a liberal view. Therefore, I was asking.
Lordship, matter will be fixed for, Lordship, so on that day also, Lordship, this also be here, Lordship.
We'll condone the delay.
But that statement is wrong, Lordship. 22/10/2019, they have said it.
Or you come up, we will take it tomorrow, day after tomorrow. You come fully briefed. Heard Mr. A. Nath, the learned counsel for the applicant. Also heard Mr. D. Chaudhary, the learned counsel for the opposite parties. When inquiry was asked to the learned counsel for the applicant as to on what grounds the review on what ground the connected review petition has been filed by the present applicants. The learned counsel for the applicant sought some time to answer to the said query. The time is allowed. Let this matter be listed day after tomorrow. That is on 26th of August.
Item 17.
May it please your lordship. Your lordship, in this case, service is completed upon all the respondents and LCR has been received, your lordship.
Heard Miss P. Thakur, the learned counsel for the appellant. Also heard Miss, what is her name?
I am appearing on behalf of respondent number 3 and 4,
Or what is her name?
Ms. J. Sharma.
Also heard Miss J. Sharma appearing for respondent number 3 and 4. On perusal of the records, it appears that the service of notice on all the respondent is complete. It also appears that
We haven't received the appeal petition yet.
the records of the concerned MSC case have also been received. Hence, this appeal is ready for hearing. Learned counsel for respondent number 3 and 4 submits that she has not received the copy of memo of appeal along with annexure. You furnished. The learned counsel for the appellant is requested to furnish the same to the learned counsel for the respondent. Let this matter be listed for hearing after 6 weeks on the date to be fixed by the registry.
Obliged.
Item 18.
In compliance of the order dated 30/11/2024,
Yes.
13/11/24, we have taken steps. And my friend is appearing on behalf of respondent number 3 also. But here is confusion is that whether he is appearing for the 2 and 3, not for 1. But order reflects that he is also appearing for 1.
Yes, Mr. Islam. For whom you are appearing?
2 and 3 years.
And 1?
I'm not.
Who is 1?
Sorry, Devri Baradu.
One is the brother of
2 and 3.
2 and 3. You take instruction whether you can appear for them. 1 also or not. Heard Mr. N. Hawk. How many respondents are there?
4. 4 years.
And other respondent number 4?
4 in Mr.
Somebody has appeared.
Hanta is there.
Heard Mr. N. Hawk, the learned counsel for the appellant. None has appeared for respondent number 4. Mr. S. Islam, the learned counsel submits that he is appearing for respondent number 1 and 2 only, 2 and 3 only. However, on perusal of the records, it appears that respondent number 1 is the brother of respondent number 2 and 3. As such, Mr. S. Islam is requested to take instructions as to whether he can also appear for respondent number 1 and let this court know about the same on the next date fix. Let this matter be.
It is short date.
Whether Trial court record will be necessary.
Possibly not required on a small issue. maybe.
Let this matter be listed at the short date, 16th of September.
Interim order.
Interim order shall continue.
Next week, any day.
Huh?
For instruction, I.
Next week, 7th of September.
In this case, I have had an affidavit of opposition for respondent to, and it is not on record, I have said.
Learned counsel for respondent number 1 and 2, so 2 and 3 submits that he has filed a written objection in this appeal. However, same is not on record. He requests to direct the registry to place the same on record. Stop. Registry shall do so and place the objection filed by the respondent number 2 and 3 along with this case record on the next date fixed. List accordingly. None has appeared for the appellant on call. On perusal of the office note dated 28/2026, it appears that service report in respect of respondent number 1, 2, 3 is awaited. The registry is directed to place postal track consignment report of notices issued to respondent number 1, 2, 3 by speed post before this court on the next date fix. List this matter on 11th of September. What is this I for?
This is a delay condonation petition, delay of 1,997 days.
None has appeared for the applicant on call. Miss R.D. Majumdar, appearing for opposite party number 3, is present. We'll fix another date. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, okay. 21, Lordship, the office note says for notice to R2 sent by speed post and usual process. And they are waiting for AD card. Lordship, they will present the postal tracking, Lordship, because it is sent by speed post. Office note dated 28/26, Lordship.
Nice. I have already instructed this section.
Yes, Lordship, it should be
Last time your lordship had directed them to place the postal track.
they should have a blanket order. They're wasting time like this.
Yes.
Court's date is wasted that
Yes,
way.
an order has been issued to the,
Okay, okay,
but
that's
they are
good.
not complying.
That's good.
Matibo একবার দুপুরিয়া মাতি. Heard Miss R.D. Majumdar, the learned counsel for the applicant. Also heard Mr. A. Bishwas, the learned counsel for respondent number 1.
Opposite party.
Sorry, opposite party number 1.
Otherwise, this is a delay petition.
On perusal of office note dated 28/2026, it appears that the service report in respect of notices issued to respondent number opposite party number 2 has not yet received. The registry is directed to place postal track consignment report of notice issued to opposite party number 2 by speed post before this court on the next date fix. Let this matter be listed 16th of September.
Highly obliged. Lord.
Super logo the R das kon hoy. Yanko matu.
May I please your lordship? Lordship, this matter has been wrongly listed in the orders column, lordship. It should have been listed in the hearing column.
For hearing, yes, my lord, because the TCR is already granted.
Heard Ms. J. Sharma, the learned counsel for the petitioner. Also heard Mr. A. Sattar, the learned counsel for the respondent. It appears that this revision petition is ready for hearing and it has been wrongly listed in orders column. As such, list this matter for hearing when.
So may I pray either on 3rd or 7th or 9th of September? The lordship pleases.
9th of September.
Right.
Obliged, lordship.
Your lordship, here in this case, we have already taken the steps, but nothing has come out from the respondent. And in the meantime, in the trial court, it is probably fixed for the argument. We challenge the ex parte order of the passed by the 18/4/2024, my lord. Title said.
You are appearing for
For respondent, my lord. Today I have filed the Okalota.
sole respondent.
Sole respondent. Yes, my lord.
Okay, we'll fix it for admission.
It may, I will file my affidavit. My lord, date may be fixed otherwise.
Yes, we'll fix it.
No,
Heard.
the judgment has it.
Dr. B. N. Gogoi, the learned counsel for the petitioner.
Lords.
Also heard Mr. P. Sheikh, the learned counsel for the respondent, who submits that you will be filing wakalatnama.
He handed over to my clerk, today.
Who submits that he has been newly engaged by the respondent and has filed his wakalatnama today only and needs some time for filing a written objection. In this case, the prayer is allowed. Let this matter be listed in admission column on 16th of September.
Deeply obliged.
Item 24.
Yes.
My lord, in this case, my lord, stay has been passed in my favor, madam. But I noticed that notice is not issued. So notice may be issued, madam.
Then we'll vacate the stay and you take steps.
My lord.
We'll vacate the stay. You take steps for issuance of notice.
Step not taken. In that case, my lord, I am sorry for that.
I am also sorry.
My lord,
You cannot
my lord,
take advantage of.
my lord, sometimes it so happen, my lord. So I may be excused, my lord. But today itself, my lord, I will take steps. And thing is this, my lord, steps regarding this notice is not issued. That is why, my lord. Your lordship will be pleased to consider by the order, stay has been granted in my favor, but notice is not issued. That is why stay is not taken,
Okay.
my lord.
Heard Mr.
My lord, I will take steps by today itself, my lord.
Heard Mr. S.A. This is item number
Item number 24. my lord.
24. Heard Mr. M.A. Sheikh, the learned counsel for the applicant, who submits that though a coordinate bench of this court by its order dated 19/12/2025 has granted the interim relief of stay of title suit number 43/2023-2022. However, by the same said order, no direction was issued for issuance of notice on the respondent. As such, steps for issuance of notice on respondent could not be taken. He submits that the petitioner is ready to take steps today itself, if so directed by the court. Stop. The petitioner is directed to take steps for issuance of notice upon how many respondents?
Respondents are there, madam.
Upon all the respondents
Numbers of stamp.
by speed post as well as by usual mode within 7 days from the date of this, within 3 days from the date of this order, returnable on 23rd September. The interim relief granted by this court by its order dated 19/12/2025 shall continue till next day, list accordingly.
Madam, notice is issued, madam.
Yes.
Obligation.
26.
May it please the Lordship. Lordship, service report may be awaited in respect of respondent number 1 to 4, and LCR has also not been received.
Heard by Sam Sakya, the learned counsel for the appellant. On perusal of office note dated 3/8/2026, it appears that service report in respect of the notices issued to respondents is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post before this court on the next date fixed. Lays this matter on 11th September. Registry shall also issue reminder for the records of the trial, records of the concerned MAC case from the concerned motor accident claims tribunal.
Lordship, we have filed an IA for stay of this appeal, Lordship. We are ready to deposit 10 lakhs subject.
How much is the awarded amount? We'll issue notice, let them appear. In IA also,
Taken steps.
IA also,
We have taken steps in the IA also.
IA also same order.
God bless Lordship.
Item 27.
Petitioners have the respondent number 4 to 6, 1 to 4, and the 7, 8, and 9.
We are the appellant, Lordship.
Application is for release of the 50% of the awarded amount.
Our application is also there, service is not complete. For all our sub except respondent number 5,
Who is respondent number 5?
the owner of the insured vehicle. The last order.
If claimants are not opposing, we may grant stay to subject to deposit of 50%.
Lordship, with direct, Lordship, we are ready to deposit or release, Lordship, it is a case of loss of no dependent. All the major sons and married daughters are claimants. So our appeal ground is that they are not dependent on the victim father. It's the ground of appeal. All are major sons working and earning and all married daughters.
How much was the compensation?
11,60,400.
How many claimants are there?
4 sons, 3 daughters. All married.
Yes, Mr. Kananda. You have any submission?
My lord, because my lord, after the death of their father, one is married, and prior to that, one son also, after the death of their prior to death of their father, one son also married. One son also married after the death of their father.
No,
So-
his
so far
submission is
my-
that The claimants are not dependents.
Because their father already expired, my lord. So as per law, this matter may be settled at the time of hearing, my lord. But at this stage, 50% may be released, my lord.
My humble submission, lordship, they are not entitled to take any amount in the.
Why? This is the
Loss of
insured
benefit.
vehicle, how they will not be entertained? It may be less or
For loss of
bigger amount.
consortium or funeral expenses, they may be entitled.
Then the undisputed amount you take it, loss of consortium and
Yes.
take 3 lakhs. How much it comes? 2,80,000 against loss of consortium.
7,000, 7 into 2 lakh, 2 lakh 80. Then
30,000.
2 lakh
3 lakhs 20,000 you take. Heard Mr. A.J. Sakya, the learned counsel for the appellant. Also heard Mr. I.A. Talukdar, the learned counsel for respondent number 1 to 4. It appears from record that by order dated 13/7/2026, this court held that notices issued to respondent number 6 to 9 were duly served. However, it appears, however, as notices were not served on respondent number 5, the appellant was directed to take fresh steps for issuance of notice on the said respondent. You have not taken steps.
Proprietors is not received till now, lordship. So
Stop.
my prayer is, lordship, that we will take a step by, try again by usual process. Earlier on, it was served to speed post, that was returned.
No, you take by
Lordship,
paper publication.
that for that, lordship, we will have to take instruction, lordship.
No, I will issue direction. What instruction?
Try to gain proprietors if possible, lordship. And one try, lordship, by usual process, we may be allowed, lordship.
The learned counsel for the appellants prays for allowing the appellant to take steps for issuance of notice upon respondent number 5 one more time by usual mode as well as by registered post. The prayer is allowed. The appellant shall take fresh steps for issuance of notice on respondent number 5 by usual mode as well as by register speed post within 7 days from the date of this order, returnable on 28th September. Why 2 I's are there?
701 is our state petition, and lordship, the other petition, lordship, 2566, they have filed for release. They are yet to depositions. They have filed for release. Direction to release.
Okay. 701 or 2566. Common order. Heard Mr. A.J. Sakya, learned counsel for the insurance company. Also heard Mr. I.A. Talukdar, the learned counsel for the claimants. The interlocutory application number IA Civil 701/2026 has been filed by the insurance company in connection with MAC appeal number 98/2026, praying for stay of execution of the impugned judgment and award dated 12/11/2025 passed by the Motor Accident Claims Tribunal Dhubri in MSC case number 102/2022, during the pendency of the connected MAC appeal number 98/2026. The learned counsel for the applicant has submitted that since in the connected appeal, the present applicant have questioned the finding of the tribunal wherein it was held that the present opposite party number 1 to 4 slash claimants were the dependent of the deceased. However, as the all our sons
1 to 4 as well as 7 to 8, 7 to 9. From 1 to 4 are sons, 7 to 9 are daughters, maid daughters.
who is appearing for 7 to 9?
I am appearing.
You are appearing.
Yes.
I Taludar for 1 to 4 as well as 7 to 9. He submits that since claimant number 1 to 4 are married son as well as claimant number 7 to 9 are married daughter of the deceased, they having their own source of livelihood, they may not be regarded as respondent, may not be regarded as dependent of the deceased. He, however, submits that the tribe insurance company is agreeable to pay, agreeable to deposit the
50%.
the amount awarded to the claimants against conventional heads. Stop. Whereas learned counsel for the claimant respondent submits that claimant opposite party submits that since the issue of dependency raised by the present applicant is to be adjudicated in the connected appeal, the insurance company may be directed to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Considering the submissions made by learned counsel for the parties, the notice to opposite party number 5 and 6 in this interlocutory application is waived. Considering the contention raised by the learned counsel for the applicant in the connected appeal, this court is of considered opinion that it would be just if at this stage this interlocutory application is disposed of by directing the insurance company to deposit the undisputed amount which may be awarded to the which has been awarded to the claimant respondent against conventional head. As such, this interlocutory application is disposed of with a direction that the execution of the impugned judgment and award dated 12/11/2025 passed in MEC case number 102/2022 D by the Motor Accident Claims Tribunal Dhubri shall remain stayed during the pendency of the connected appeal, MAC appeal number 98/2026, subject to deposit of an amount of rupees 3,20,000 by the insurance company before the registry of this court within a period of 4 weeks from the date of this judgment. Stop. If such deposit is made by the insurance company, same shall be disbursed to the claimant's opposite party by the registry after proper verification. The interlocutory application number 701 and 701/96 and 2566/96 are accordingly disposed of.
May I please, Your Honor? Your Lordship, kindly matter be taken after some time as Mr. Arofi lacks in another court, Lordship.
May I praise your lordship? Your lordship, I am appearing for both the respondents. I need another 2 weeks time to file my objection.
Okay. Heard, what is her name?
Yeah, free.
Heard Miss A. Afreen appearing for the applicant in this case. On the other hand, Miss
Tidas.
T. Das, learned counsel for the respondents, praised for some time for filing a written objection in this case. The prayer is allowed. Let this matter be listed after 2 weeks.
May it please your Lordship. Lordship, the office note does not show any service on respondent number 5 and 6, though we had taken steps by usual as well as speed post, Lordship. Only mention about respondent number 1 to 4.
Heard Miss Adi Majumdar, the learned counsel for the appellant. Also heard Mr. M. Talukdar, appearing for
Respondent number 1 to 4.
respondent number 1 to 4. The learned counsel for the appellant submits that the appellant, in pursuant to the directions of this court, has taken steps for issuance of
23/6/2026.
notice upon respondent number 5 and 6 on 23/6/2026 by usual mode as well as by speed post. However, the office note does not reflect the same. Stop. Registry to verify and put up this case again after proper office note. Stop. In the event it is found that the appellant has taken steps for issuance of notice upon respondent number 5 and 6 by speed post as submitted by learned counsel for the appellant, the registry shall also place the postal track consignment report of the notices so issued by speed post before this court on the next date fixed. Let this matter be listed.
Reminder for LCR, Lordship,
9th of September.
it shows that LCR not received. So reminder for
The registry shall also issue a reminder for the reminder for requisitioning the records of MEC case number 52/2021 from the concerned tribunal. List accordingly.
We have filed an application for release of the
50% of the awarded amount deposited by the insurance company.
Any stay is there.
Lordship, we have filed our objection because Lordship in this, and let notice go Lordship at this stage in their IA Lordship. Let notice to the owner.
The stay has been granted.
Granted, Lordship.
Granted.
Subject to deposition of 50%.
Lordship, because in this case, Lordship, the case was filed against the deceased for driving rash and negligently, and we had reduced evidence to prove that the deceased was responsible. The police officer came and adduced evidence that the deceased was responsible for the accident. That's why, Lordship, adjudication will be necessary in this case.
Lordship,
Let them send the notice first,
But-
let the owner and driver appear, Lordship. After that, Lordship will take up the IA.
the case they have been referring is not related at all with the present case, Lordship. Lordship,
That
not
will
at all
need final
related.
hearing,
One,
Lordship.
one non-FIR case has been lost at Sirukundi in the district of Kachar. And that case has no relation with the present regular PS case. Lordship. Lordship, see, and they based their
About a different incident.
different incident that was lost only because the rider was not wearing helmet.
That was,
And this is a regular case, regular PS case.
no, Lordship.
Charge sheet has been submitted in this case, Lordship.
No, Lordship. Lordship, the FIR in this case itself was registered. That's why we have filed our objection,
They
Lordship.
are basing that their
FIR in this case, we are also saying fraud, Lordship, because the FIR was lost after I think 1.5 months.
no.
Yes, not
5
immediately.
days. I have the copy.
That's why, Lordship, final full hearing will be necessary, Lordship. Let them send the notice here. Lordship, we cannot allow fraud to be.
No. What is no question of fraud, Lordship?
There is fraud, Lordship, in this case.
Okay, you take steps for issuance of notice.
Lordship,
Take steps for issuance of
Lordship,
notice.
kindly see that. I have all the documents with me.
No.
They have no case at all, Lordship.
We'll consider your submission.
Lordship, several days have been given in this case.
No, Mr.
Lordship.
Listen to me. Be cool. Listen to me. You have filed an interlocutory
Lordship,
application, making some persons as opposite parties.
Lordship,
Are they not entitled to get notice?
Lordship, for the disposal of this case, notice is not required.
Then why have you made them opposite parties?
And that's why your Lordship has not passed any order for issuing notice. Lordship, can you see any order is there?
No, whether they are entitled to get notice or not.
Entitled Lordship for disposal of the interim, this miss case, not required, Lordship. And in fact,
No, in view of the objection raised by the other side.
objection, Lordship, can you see that their objection? Beg statement, Lordship.
Okay,
All are beg
you
statement.
take steps for issuance of.
And charge sheet has been filed against the dead person. They are pleased that. And because the notice was not sent to the owner and driver, the interim.
Who is Soma
application is not maintainable.
Chakravarti
Owner,
and Shaheen Ahmed?
right.
You take steps for issuance of notice.
They base their case only on the evidence of their investigator. Investigator said that he has not seen the incident. He was not there. On the other hand, charge sheet is there. Police, after investigation, submitted charge sheet against the driver of the oil tanker.
No,
It's a fleet case.
we will consider your submission.
This way, that was delaying the matter, Lordship, other side. On several episodes, that took time. Lordship, kindly see the report.
This I is coming for the third time.
Lordship. Third time.
Heard Miss
In the
Mr.
meantime,
in I heard Mr. M. Talukdar, learned counsel for the applicant. Also heard Miss R. D. Majumdar, learned counsel for the opposite party. number 1/insurance only.
Lordship, my further submission is that in another case arose out of the same incident, court allowed to withdraw the money, deposited the money.
The learned counsel for the opposite party submits that the opposite party number 1 insurance company has filed a written objection in this interlocutory application. Alleging fraud on the part of the claimant.
So after 5 days of the incident, that they lost the affair.
She further submits that
And for
the
delay,
notice. No,
it has been mentioned.
I'm issuing notice. She further submits that since in this interlocutory application, notices were not issued to the owner and driver of the offending vehicle, it would be appropriate that before deciding this interlocutory application, they are notified about pendency of this interlocutory application. This court also deems it proper to decide the issue involved in this interlocutory application only after due service of notice on the other opposite parties, namely opposite party number 2 and 3. As such, the applicant is directed to take fresh steps for issuance of notice upon opposite party number 2 and 3, in this interlocutory application, by speed post, as well as by usual mode, within 7 days from the date of this order, returnable 25th
Date
September.
may be fixed.
25th
And
September.
my further submission is that if notice is not served after taking steps,
Yes.
then what will happen also?
Wait for 25th
25th.
September.
25th, that may be, that this case may be disposed of on that case.
I
So they took time also.
I said wait till 25th September.
And on the other hand, Lordship, another case arose out of the
Highly
same
obliged,
incident.
Lordship.
No,
This
Mr.
one would allow to
Mr.
withdraw the-
Talukdar, reserve something for 25th also.
Lordship, obliged.
Main appeal to 25th.
No, see, as per office note dated 28, service report on respect of respondent number 2 and LCR both may be awaited, Lordship.
Heard Mr. A.J. Sakya, the learned counsel for the appellant. Also heard Mr. A.R. Agarwala, the learned counsel for respondent number 1. You are for?
I am for claimant, Lordship, one respondent claimant.
Respondent number 1/claimant. It appears from office note dated 28/2026 that the service report in respect of respondent number 2 is awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post before this court on the next date fixed. The registry shall also issue reminder for the records of MAC case number 256/2018 from the concerned tribunal. List this matter again on
Lordship, this 4 lakhs
When?
was while granting stay, Lordship,
16 September.
while granting stay, Lordship, the amount has not been deposited yet, so that may kindly be. This is on the process, Lordship, we have already given some time. Simply may kindly mention that they have not.
No,
deposited.
if they don't deposit,
Yes,
then
yes,
there is no stay.
there is stay, Lordship.
Stay is
That
subject.
the amount has not been deposited, Lordship. So my humble
Yeah.
submission that deposit may kindly be expected by 1266.
No, stay was granted subject to deposit.
Yes, Lordship, but deposit is not being affected.
That means stay is not operative. You can go for execution.
I'm submit that.
Then
they
wait
can be-
wait for some time.
Really.
The affidavit has been filed. It was served upon us on 30th of July.
The matter may be fixed for admission here, your lordship.
I may be permitted some time to file a small rejoinder to the affidavit, my lord.
Heard Mr. What is your name?
And thus,
And thus, the learned counsel for the petitioner. Also heard Miss A. Bhuya. What is your name?
Yes.
Also heard Miss M. Das, the learned counsel for the sole respondent, who submits that the respondent has submitted his affidavit in opposition. Its affidavit in opposition. Stop. The learned counsel for the petitioner prays for some time to find a reply to the affidavit filed by the respondent. The prayer is allowed. Let this matter be listed in admission in hearing column after 2 weeks on a date to be fixed by registry.
my lord, can it be a fixed date?
Hmm?
Can it be a fixed date, my lord? 9th of September, if it pleases, 9th September.
Fixed date will be difficult.
Okay. No problem.
42.
May I please the lordship? Lordship, on 21/8/2026, steps were taken, lordship, by speed post, lordship. Lordship, I am praying for the awaited service report, lordship.
You are appearing for?
Number 7.
You are appearing for state respondents. Heard Miss Are they the learned counsel for the applicants? Also heard Mr. What is her name? A. Wahid, appearing for respondent number 7, as well as Miss M. Kolita, appearing for respondent number 8, 9, 8, 11, and 12. But earlier you appeared for 8, 9, 10, 11, and 12.
No, lordship.
Who is appearing for 9? For 8, 11, and 12. On perusal of the office note dated 19/6/2026. You have not taken steps by speed post.
Step was taken, lordship, on 21/8, lordship.
By speed post?
Yes, lordship.
On perusal of office note dated 19/6/2026. It appears that the service report in respect of notices issued to respondent number 1 to 7, 9, 10, 13, 14, 15, and 16 is awaited. The learned counsel for the petitioner submits that the petitioner has also taken steps for issuance of notice upon above mentioned opposite parties by speed post also. Stop. In view of the above facts, comma, the registry is directed to place the postal track consignment report of notices issued to aforesaid respondents by speed post before this court on the next date fixed. Let this matter be listed on 14th of September.
Right, Lordship.
Lordship, by big indulgence, item 20, I missed the call, Lordship. Lordship, we please to record my presence, Lordship.
Item 28,
22-0. It speaks of that.
item 20, reflect the name of Ms. T. So as learned counsel for the applicant.
In that case, they were supposed to take steps, whether they have taken.
We have taken steps. We have taken.
The one I.
What was the order?
For one, we have.
The
taken-
order is.
None appears, list it after so and so.
We have taken steps, Lordship. In respect of one, because other two respondents were there.
Record to Anil.
But we'll take again a few steps. There's steps.
Okay, we'll take it up after some time. Let the record come.
Apologies, Your Lordship. Item 31, there's an interim order, Your Lordship.
Item?
There's an interim order.
Item
31.
31, interim order shall continue till next day.
May I please? I'm applying for respondent. Application preferring a how 129 days delay. I have filed objection, Pratik. Can you peruse my paragraph number 4 in my objection, page number 10.
Page number? Yes.
Page number 10.
Yes.
Their main contention is that they have engaged their counsel. In their application at paragraph number 2. In their application at paragraph number 2, can you go on? The petitioner may I read it?
Yes.
So the petitioner states that after taking advocates their brief, Mr. Shantanu Kumar Sarkar, they engaged another advocate, Mr. Pankaj Das, and his associate, who argued in the misdeed case number 46 of 2024, entitled with number 1, another pending application on behalf of the petitioner. Thereafter, on 1911, the petitioner had engaged another advocate along with Mr. Pankaj Das and his associates. So this Pankaj Das was engaged on 1911-2025, according to the contention of their paragraph number 3. But surprisingly, very next paragraph, that the petitioner states immediately after passing the impugned order dated 18/8/2025 in Midze case number 46, the petitioner took advice from their engaged advocate, Mr. Pankaj Das. So they state two contradictory statements here, Lordship. So my contention is whether the petitioner applicant have there any malafide in connection. And surprisingly, Your Honor, they have applied the certified copy of the Midze case order on 6/11/2025 after 4 months of passing of the Midze case order, injunction order. And they have yet explained as to why they have applied for certified copy at a belated stage. So, in such a situation, I have stated the delay occurred not on because of any malafide part on the part of the applicant. According to B. Otherwise, 129 days delay.
Yes, Mr. Mukherjee.
is what he has explained, that is not my contention. My contention is that after first they have applied, engaged Mr. Santanu Kumar Sarkar. Thereafter, the advocate briefs were taken, and they have engaged Mr. Pankaj Das, who argued the miscase. Miscase was argued by the Pankaj Das, not Santanu Kumar Sarkar. Yes. And in the meantime, after passing of that order, they have engaged another counsel, that is me and my associates, and along with the Pankaj Das. Pankaj Das was not removed. Another Wakalatama was filed along with the Pankaj Das and others. Thereafter, in the meantime, after passing of this order, the petitioners asked their counsel, Pankaj Das, to prepare the necessary appeal for preparing for this honorable court. But he has not preferred the appeal and has not prepared the memo of appeal.
Who?
The Pankaj Das, earlier counsel. Thereafter, they engaged me, and I prepared the memo of appeal along with this application. In the meantime, there was a delay of 129 days. And immediately after passing of the order, we have
Which order has been impugned in the FAO? Collected appeal.
18/8/2025, last in this case.
What was the order?
Order was that injunction order was granted
In favor of?
in favor of the petition, respondent.
Actually, the order was not in favor, because there is another defendant. The order authority portion is affected only in that section.
Can you peruse the order?
No, you have not explained why you applied belatedly for certified copy.
Hello, we have asked our earlier counsel to prepare the memo of appeal and apply the certified copy.
And you have given a contradictory statement that you engaged Pankaj Das on 19/11/2025.
No, 1911 was engaged to me.
No.
Not Pankaj Das. Pankaj Das was along with Pankaj Das, another sets of advocates were engaged. Page number 4. And thereafter, on 19/11/2025, the petitioners have engaged another advocates along with advocate Mr. Pankaj Das and his associates. To conduct the title suit.
Third, Mr. A.K. Gupta, the learned counsel for the applicant. Also heard Mr. B. Fukon, the learned counsel for the opposite parties. This interlocutory application under Section 5 of the limitation of 1963 has been preferred by the applicants for condoning the delay of 29 days in filing the connected first appeal against order, wherein the order dated 18/8/2025 passed by the Court of Learned Civil Judge, Senior Division, number 1, Kamrup Metro, Gauhati, in Ms. J case numbers 46/2024, arising out of title suit number 25/2024, has been impugned. the learned counsel for the applicant has submitted that though after passing of the impugned order, the present applicant had instructed his engaged counsel, namely Pankaj Das, to prepare the memo of appeal and file the same. However, for considerable time, the engaged counsel did not take any step for preparation of memo of appeal. As such, the applicant had to engage another counsel and instruct him to prepare memo of appeal. And in the process, delay of 129 days occurred, and the appeal could only be filed on 26/3/2025. He submits that the delay caused in filing the connected appeal was occasioned because of the lapse committed by the engaged counsel for the present applicants, namely Shri Pankaj Das. He submits that the applicants were not at fault and the delay occasion in this case was not intentional and there was no malafide on the part of the present applicants. On the other hand, Mr. B. Fukon, the learned counsel for the opposite party, has objected to the prayer of condonation of delay of 129 days. He submits that the delay of 129 days has not been properly explained by the applicant by giving sufficient reasons for the same. He submits that on the one hand, the applicant has stated that it is on 19/11/2025 the applicant has engaged Mr. Pankaj Das and his associates. Whereas on the other hand, it is also stated in the application that on 18/8/25, after passing of the impugned order, the applicant took advice from the engaged counsel, Mr. Pankaj Das, and requested him to prepare the necessary appeal. Stop. He further submits that in the instant case, even the certified copy was applied. Certified copy of the impugned order was applied for on 6/11/2025. That is almost after a lapse of 3 months from the date of passing of the impugned order. He therefore submits that the applicant has malafidely caused delay in preferring the connected appeal and has failed to explain the reasons for delay in the instant case. I have considered the submissions made by the learned counsel for both sides and have gone through the materials on record. In this case, it appears that the statement made in the instant interlocutory application, which is supported by an affidavit, shows that immediately after passing of the impugned order dated 18/8/2025 in Ms. J case number 46/2024, the applicant instructed his their engaged counsel, Mr. Pankaj Das, for preparation of appeal and filed the same before the appropriate court. However, it appears that the engaged counsel committed lapse in doing so within the prescribed period of limitation. It also appears from record that the applicants have taken back brief from the said counsel and have engaged a new set of counsel in this case. So, it is settled proposition of law that while considering an application for condonation of delay under Section 5 of the Limitation Act, a liberal and justice-oriented approach has to be taken by the courts. As such, considering the facts stated by the applicant in the instant interlocutory application, this court is of considered opinion that there was no malafide on the part of the present applicants. Rather, they were prevented by sufficient cause in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 129 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected first appeal against order and list the same for admission after a week on a date to be fixed by the learned counsel for the applicant. Learned counsel for the applicant. What is this application for?
For
Oh.
condoning delay, Lordship.
Okay. Learned counsel for the applicant. Also Miss R.D. Majumdar, the learned counsel for opposite party number 3. It appears that the notice issued to opposite party number 1 has returned with an endorsement within inverted comma, addressee is not available. What will you do? Take fresh steps.
Will take fresh steps, Lordship.
The applicant is therefore directed to take fresh steps for issuance of notice upon opposite party number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of September.
And obliged, Lordship.
My lord, this is a delay control petition. Following a delay of 56 days in respect of file a review application, my lord. My lord, notice was sent to the respondent of 1, 2, and 3, my lord. Here in the cause list, I have seen that respondent 1 and 2, advocate's name is reflected. So regarding the respondent number 3, in office note, there is no any mention regarding the service of.
Mr. Kolita, you are appearing for?
1 minute, 1.
You have any objection?
The election manner, the explanation manner, of course, the delay is not too long or 56 days manner. But the explanation is not sufficient manner because that should be kindly see page number 6 of the IA manner. The order sought to be reviewed was passed on 27 to 26 manner. And Lordship may kindly see paragraph number 6.
Yes.
Passing the order 27 to 26 in the aforesaid IA, the petitioner willing to file review petition and according to the petitioner instructed the present engaged counsel to apply certified copy of dismissal order against the IA. And on instruction, the engaged advocate filed on 4/5/26. In between, my lord, there was no
the notice to other respondents have not yet served. However, considering the pleas taken by the petitioner in the instant interlocutory application, as well as considering the fact that the insurance company is represented by his engaged counsel, the notice to other opposite parties is waived in this case. This interlocutory application has been preferred by the applicant under Section 5 of the Limitation Act 1963, praying for honoring the delay of 56 days in preferring the review against order dated 27/2/2026, passed in IA Civil number 592/2025, whereby the said interlocutory application was dismissed. The main reason shown by the present applicant in the instant interlocutory application for delay in preferring the review beyond the prescribed period of limitation is that the engaged counsel for the applicant could not inform her about the dismissal of her earlier interlocutory application, as the applicant had lost her mobile. Stop. The learned counsel for the applicant submits that as he was the engaged counsel of the applicant in earlier interlocutory application, he tried on several occasions to intimate the applicant regarding dismissal of her earlier interlocutory application on 27/2/2026, however, it is only on 3/5/2026 the engaged counsel could inform the applicant regarding dismissal of the earlier interlocutory application. Stop. Thereafter, on the very next date, the engaged counsel for the applicant applied for certified copies of impugned order, and in the process, delay of 56 days as occasion in preferring the connected review application. On the other hand, the learned counsel for the insurance company, Mr. T. Kolita, has objected to the prayer for condoning the delay on the ground that the applicant has not clearly indicated as to why from 27/2/2026 till 3/5/2026 the applicant was unaware about the order dated 27/2/2026. He submits that the submissions made by learned counsel for the applicant that he tried to contact the applicant on several occasions has not been pleaded in the instant interlocutory application. He therefore submits that the instant interlocutory application lacks merit and deserves to be dismissed. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Though the main contention of the applicant in this case is that she had lost her mobile, hence the engaged counsel was unable to inform her regarding the fate of earlier interlocutory application, however, she has not indicated as to on which date her mobile was lost and when she procured a new mobile. And stop. However, though there are lapses on the part of the present applicant in pleading the facts properly in this interlocutory application, which occasioned the delay of 56 days in preferring the connected review application. This court is taking a lenient view of the matter and is inclined to condone the delay in this case. As such, the delay of 56 days in preferring the connected review application is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected review application and list the same in orders column on dated 7 September.
Hello.
May it please your lordship? Your lordship, this I is for condoning the delay of 2 days in filing the substitution petition, your lordship.
2 days. You are opposing?
No, Lordship, we don't have.
Heard Ms. P. Thakur. I number?
I civil number 1942 of 2026.
Heard Ms. P. Thakur, the learned counsel for the applicant. Also heard Mr. A. Ali, appearing on for which
Respondent number 1, Lordship.
appearing for opposite party number 1. Since the opposite party number 1 is the claimant in this case, the notice to other opposite parties in this interlocutory application is waived. This interlocutory application has been filed by the applicant for condoning the delay of 2 days in preferring the application for substituting the legal heirs of
Respondent number 1, your lordship, claimant. Your claimant
Respondent number
expired.
1. Claimant who has expired on
2/1/2026.
2/1/2026. The prayer is not opposed to by the learned counsel for the other side. So, considering the reasons stated in the instant interlocutory application, as well as considering the short period of delay involved in this case, the delay of 2 days in preferring the substitution application is hereby condoned, and this interlocutory application is allowed.
Lordship, I civil 19412026 is for setting aside abatement.
लास्ट ऑर्डर का लास्ट लाइन बढ़िया था. Substitution application, comma, and application for setting aside abatement is hereby condoned. This next 1941, this interlocutory application for setting aside abatement of MAC appeal number 570/2025 on failure to substitute the legal heirs of respondent number 1 on his death has been filed by the New India Insurance Company applicant. Learned Mr. A. Islam, A. Ali, the learned counsel for the applicant, has no objection to the prayer made by the. Who is respondent number 2?
Respondent number 2, respondent number 1 was represented by respondent number 2, Your Lordship, since respondent number 1 was bedridden. Mukut Sharma.
Who is representing him? Mr. Ali, you are also representing respondent number 2. How no?
Respondent number 2, already services completed, Your Lordship. In the main appeal, 2 and 3 services completed, but not represented, Your Lordship.
After considering the grounds stated in the instant interlocutory application, as well as considering that the learned counsel for opposite party number 1 does not have any objection to the prayer for setting aside of abatement, this interlocutory application is allowed, and the abatement of appeal, abatement of connected appeal on the death of late Nabhakumar Goswami alias Nabha Goswami is hereby set aside. Next,
I civil 1940 of 2026. It's for substitution of legal heirs. Respondent number 1.
1940. Heard Ms. P. Bhattakur, learned counsel for the applicant. Also heard Mr. A. Ali, the learned counsel for claimants. Respondent. This application under Order 22, Rule 4 of the Code of Civil Procedure has been filed by the applicant insurance company in connection with the MAC appeal number 570/2020, praying for substituting the legal heirs of deceased respondent number 1 in his place in the connected appeal. The learned counsel for the applicant has submitted that the respondent number 1 has expired on 2/1/2026, leaving behind following legal heirs. Number 1, Srimati Binapani Goswami. Number 2, Srimati Aarti Devi. She submits that there was a delay in filing of the instant substitution application. However, in the connected interlocutory applications filed by the present applicant, the delay has been condoned and the abatement of appeal has also been set aside. Stop. She submits that the legal heirs of deceased respondent may be substituted in his place as respondent number 1 within bracket 1 and respondent number 1 within bracket 2 in the memo of appeal. The prayer is not opposed to by learned counsel for the other side, and same is allowed. The appellant is directed to submit a corrected memo of cause title in the memo of appeal showing the legal heirs of deceased respondent, namely Srimati Binapani Goswami as respondent number 1 within bracket 1 and Srimati Aarti Devi as respondent number 1 within bracket 2 in place of the deceased respondent. Let this matter be listed again after 2 weeks on a date to be specified.
Obliged.
The disposal.
Well, here in this case, I have filed an interlocutory application for releasing the 50% of the awarded amount. What had happened, this appeal is pending since 2019. And after that accident.
Whether any stay was granted.
Yes, stay was granted.
Granted, Lordship, and it is ready for hearing. Either they send a notice or the hearing in September or next week.
The
September.
last occasion also
Stay
several dates has been fixed for hearing. Now, problem is that he is continuously check up his. Not after the accident, he lost his job also. He has already expended huge amount. Now, still he is check up his fractures in the Patna. So he is now facing the acute financial.
What is your ground?
Ground, Lordship, there was no driving license.
But that ground, they could not establish from the judgment itself is clearly.
That's why we have filed the appeal, Lordship, that we have proof that the person did not have a driving.
Mr. Moria, you are appearing for?
This one number 2.
What judgment?
Driving license is there.
Yes.
They appointed one investigator and he stated that there is one old driving license number mentioned. And he said that old driving license that bears word NL, NB, that means it is issued from Nalbari. But the letter tribunal has not accepted the other contestant because nowhere it is stated that whole driving license
Yes.
is for the other.
Let us categorically,
That will need a full hearing.
categorically
We'll hear the matter,
Yes,
but
Lordship.
we'll direct the disbursement of amount, subject to furnishing of indemnity bond.
yes.
Third, Mr. R. Islam, learned counsel for the applicant. Also, Ms. R. D. Goswami, learned counsel for the respondent insurance company, as well as Mr. R. D. Majumdar, learned counsel for opposite party number 1 insurance company, as well as Mr. H. L. Moria, appearing for the opposite party number 2 / owner of the offending vehicle. This interlocutory application has been filed by the applicant / claimant in connection with MAC Appeal number 357/2019. Praying for releasing the 50% of the awarded amount which has been deposited by the insurance company before the registry of this court in person to the directions issued on
That order is at page 11.
17/7/2019, passed in IS civil number 2288/2019. Stop. Learned counsel for the,
My lord,
yes,
I may be late, my lord.
yes. You may not get the money.
My lord.
No, leave. You may go. The learned counsel for the insurance company has objected to the pair on the ground that the driver of the offending vehicle was not having valid driving license at the time of accident. Stop. On the other hand, learned counsel for the owner of the offending vehicle has submitted that the driver was having the driving license at the time of the accident, and he was holding the old driving license.
Oh, my lord, in the driving license, new and both were mentioned.
Stop. And last line, cut them. Stop. The contention regarding validity of driving license of the driver of the offending vehicle at the time of the accident has to be decided in the connected appeal. And the connected appeal is already ready for hearing. However, considering the pendency of the appeals in this court, the said appeal is unlikely to be heard before the month of December.
September, because it was already listed for hearing. We
No,
waited in the court for hearing, so
but
the item did not reach.
item did not reach.
It will now be listed after December only.
But nowadays, Lordship, the cases are listed in different courts. Various courts are getting 1 or 2 MSc appeals. Lordship might have seen the cause list. So that way, not December, Lordship, let registry list the case.
December.
or can it be?
December. Hence, this court is of considered opinion that it may not be appropriate to deprive the claimant from the fruits of litigation for such a long period. As such, this interlocutory application is allowed and the registry is directed to release the 50% of the awarded amount which has been deposited by the insurance company before the registry, subject to furnishing of an indemnity bond equivalent to the amount to be disbursed to the claimants, as well as after proper verification. This interlocutory application is accordingly disposed of. In the connected appeal, heard Mr. R. Islam, learned counsel for the appellant. Also Miss R. D. Majumdar, learned counsel for the insurance company, as well as Mr. H. L. Moria, learned counsel for the owner of the offending vehicle. This appeal is ready for hearing. Let this matter be listed for hearing. Fixed date. 3rd of December.
No, Lordship, after registry, Lordship, 3 weeks or something like that. Because cases are being listed.
After 4 weeks, cut them. After 4 weeks on a date to be fixed by registry.
Alia.
No common order. Yes. This is I for none has appeared for the applicant on call. Mr. Mr. K. Bhatto, learned counsel for opposite party number 1 is present. Stop. Peruse the office note dated 28/2026. The registry is directed to place the postal track consignment report of notices issued to respondent number 2, 3, and 4 by speed post before this court on the next date fixed. Let this matter be listed 9th of September.
See, in this case, steps were taken on respondent number 2 and 3, both ways, Lordship. Speed post returned that it is in respect of 2, try at Melville BO, and in respect of 3, and respondent number 3 left the place. So 2 and 3 could not be served by way of postal by speed post, but the usual process is not returned. The usual process, it might have been served, Lordship. So some time may be awaited, I think.
Heard Mr. A.J. Sakya.
My lord, I am on behalf of 1 and 2.
1 and 2. You are on behalf of 1 and 2.
In respect of respondent number 2, I have not filed Wakalat. I will file next step before the next step matter.
So in respect of 3 only, we will have to. Okay.
Also heard Mr. B. R. Das, learned counsel for respondent number 1, who submits that he has also been instructed to appear on behalf of respondent number 2 and he shall be filing his wakalatnama shortly. And some time is paid for the same. On the other hand, on perusal of the office note dated 19/8/2026, it appears that notice to respondent number 3 has returned with an postal endorsement within inverted comma left. It also appears that notice sent to respondent number 3 by usual mode has not yet been received back. As such, await for some time. Let this matter be listed again on 16th of September.
So here, although the last office note says that we have not taken steps, Lordship, but we have taken steps on 21/8. So service may be awaited, Lordship.
By speed post,
Speed post, Lordship.
heard Mr. S.P. Sharma, the learned counsel for the applicant. Though office note dated 28/2026 shows that the applicant has not yet taken any steps for issuance of notice upon the respondent, however, learned counsel for the applicant submits that the applicant has taken step on which date?
On Lordship, 21/8, we have taken steps.
On 21/8/2026. Stop. The registry shall verify the same. And if such steps has been taken, it shall place before this court on the next date fixed the postal track consignment report of notice issued to respondent by speed post before this court. Let this matter be listed 10th of September.
42.
Yes.
Forest. Private is not.
Heard Mr. K.K. Bhutto, the learned counsel for the applicant. Also heard Mr. What is the name?
So S Sharma for forest matter. Yes, for number 6.
Mr. S. Sharma, appearing for respondent number 6. On perusal of the office note dated 19/8/2026, it appears that notice issued to respondent number 4 has returned without service, whereas notice issued to respondent number 1, 2, 3, and 5 have not yet returned. What will you do?
So regarding respondent 4, against the quantum, it is or is against the quantum. Let's see, we have challenged the quantum amount. So yes, name of the respondent number 4 may be strike out.
Who is respondent number 4?
This one driver is.
And against 1, 2, 3, 4, 3, 5?
Yeah.
The learned counsel for the applicant submits that since in the connected appeal, the applicant has impugned the quantum of the award, quantum of the compensation awarded to the claimant Hence, notice to respondent number 4, comma, who is the driver of the offending vehicle, comma, may be waived. Stop. The prayer is allowed.
My lord, hey, my lord, there was some communication gap, my lord. Apart from the quantum, my lord, there are few other grounds, my lord, which we have tried to, my lord, hesitate in this appeal. So, my lord, 4 will be required. 4.
In paragraph continue. Cut this. You take steps by for paper publication.
My lord, we can do that. In fact, my lord, if your lordship awaits the service report with regard to the speed post which we have taken, my lord. The speed post, the service report has not come back.
Okay.
These are only with regard to the usual steps.
It appears that the notices were also issued
Some
to respondent number 1, 2, 3, 4, and 5 by speed post, and service report in respect of same is not available. Hence, the registry is directed to place the postal track consignment report of notices issued to above mentioned opposite parties by speed post before this court on the next date fixed. Let this matter be listed on 14th of September.
14th of
September.
My lord, in 43, my lord, the office note says unserved notices of respondent 4 and 5 are returned back because of insufficient address. And with regard to 6 also, my lord, the principal employee is served. This is an analogous case, my lord.
Analogous with the earlier one.
My lord. So AD card on other respondent 1, 2, 3, and 7 are awaited. One.
Heard Mr. R.K. Bhatra, the learned counsel for the applicant. On perusal of the office note dated 19/8/2026, it appears that notice issued to respondent number 6 has been duly served, whereas unserved notices to respondent number 4 and 5 have returned with postal note within inverted comma insufficient address. The service report in respect of respondent number 1, 2, 3, and 7 is awaited. 4 and 5 you take fresh steps.
My lord, we'll do that.
The applicant is directed to take fresh steps for issuance of notice upon respondent number 4 and 5 by speed post as well as by usual mode. As regards respondent number 1, 2, 3, and 7, comma, the registry shall place the postal track consignment report of notices issued to aforesaid respondents by speed post before this court on the next date fixed.
My lord, if your lordship
Same date.
My lord, if your lordship peruses, the respondent number 6 is state of Assam and 7 is the divisional forest officer, which my lord, my learned colleague has just now appeared in the item 42. So if permitted, I can serve a notice.
You serve a notice, next day we will pass order.
Ma'am.
Yes.
Oblige.
List this on 14th of September.
17th of September. Oblige.
Item 44.
May I please, your lordship? Lordship, by the mistake of our office clerk, my lord, we have not taken steps on respondent number 4 and 5, my lord. So 3 days time may be allowed, my lord.
Heard Mr. N. Sharma.
And he has not filed objection, my lord.
The learned counsel for the applicant. Also heard Mr. B. R. Das, appearing for respondent number 1 to 3 / claimants. Learned counsel for the applicant submits that due to some communication gap, the applicant could not take steps for issuance of notice on respondent number 4 and 5. As such, some time is prayed for the same. The prayer is allowed. The applicant shall take steps for issuance of notice upon respondent number 4 and 5 by speed post as well as by usual mode within 7 days from the date of this order returnable on 28th of September.
11:45. Oblige me.
My lord, this is an IA, my lord.
Lordship, I am appearing for respondent number. I will be appearing. Lordship will be filing a wakal number today.
For
Respondent number 1. New India Assurance.
heard Mr. B. R. Das, the learned counsel for the applicant. Also heard Mr. S. P. Sharma, the learned counsel for New India Assurance Company Limited, who submits that he has been instructed by opposite party number 1 to appear in this case, and he would be filing his wakalatnama shortly. It appears from record that notice issued to opposite party number 3 has been duly served, whereas service report in respect of notice issued to respondent opposite party number 2 is awaited. The registry is directed to place the postal track consignment report of notice issued to opposite party number 2 before this court on the next date fixed. Let this matter be listed. 16th of
My lord, copy I am serving. That may be.
16th of September.
Item 46.
May I please? As per office note dated 28, 2026, a notice upon all the respondents complete.
Heard Mr. A. Bhattacharya, the learned counsel for the applicant. Also heard Mr. A. N. Das,
Respondent number 3.
appearing for opposite party number 3. On perusal of office note dated.
Respondent number 1 and 2.
Also heard Mr. R. Islam, appearing for opposite party number 1 and 2. You have any objection?
To file objection.
Learned counsel for the opposite parties praised for some time for filing written objection in this interlocutory application. The prayer is allowed. List this case again on 16th of September.
Obliged.
Obliged, Your Honor.
Item 47.
Here, my lord, the service report awaited. We have taken steps.
Heard Mr. A. Bhattacharya, the learned counsel for the applicant. On perusal of the office note dated 28/2026, it appears that service report in respect of notices issued to the respondent opposite parties is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to the opposite parties by speed post before this court on the next date fixed. Let this matter be listed
Yes.
on 10th of September.
Obligation.
Yes.
48.
What is 48? 48.
But
Wow.
this case, my lord, to file for IA or withdraw the 50%.
Please, your lordship.
No problem, my lord, we have changed the DL because we have reduced a defense witness that landed court below did not consider. So immunity bound may be.
My lord, here, my lord, if your lordship see the paragraph 34 of the judgment, then your lordship will find, my lord, driver
he is
possessed
not-
of valid driving license.
He is not opposing.
Yep.
Mr. Paul is not opposing your prayer.
Yes, but
He is only
insisting on the
insisting on-
indemnity bond.
So submit indemnity bond.
Well, I can submit, but here, my lord, this judgment itself cleared, my lord, paragraph
No,
34.
we will not go into that questions now.
Driver possess valid driving
Heard
license.
Mr. M. Dutta, the learned counsel for the applicant. Also heard Mr. R.C. Paul, the learned counsel for the opposite party insurance company. This interlocutory application has been filed by the applicant slash claimant, praying for allowing the applicant slash claimants to. How many claimants are there?
Only one.
Claimant to withdraw the 50% of the awarded amount deposited by the insurance company before the registry of this court in person to order dated 23/3/2026 passed in IA Civil number 947/2026 in connection with MSC Appeal number 125/2026. Staff. The learned counsel for the insurance company has not opposed to the prayer. His only submission is that the applicant may be asked to submit an indemnity bond as the question of validity of the driving license of the driver of the offending vehicle has been raised in the connected appeal. Stop. After considering,
Other grounds also there.
as well as some other grounds. Stop. After considering the submission of learned counsel for both sides, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the New India Assurance Company Limited before it in person to the order dated 23/3/2026 passed in IA Civil number 947/2026 to the claimant Srimati Anoda Das, subject to furnishing of an indemnity bond equivalent to the amount which is to be disbursed to her in pursuant to this order and after proper verification. This appeal is accordingly, this interlocutory application is accordingly disbursed.
Also, may I play one thing, my lord? My lord, the applicant is a 76 years old lady, my lord. And my lord, it was due to the accident was her husband was expired in this accident, my lord. So my lord, here, my lord, the tribunal has directed to deposit, my lord, 20 numbers of FDRs of 10,000 each. So my lord, may instead of my lord 2
No,
lakhs, my lord,
This 50 will be without any condition.
if lordship, my lord, 75,000 or 1 lakh, I will keep 75,000. I will keep in fixed deposit, my lord.
No, this 50 you can take without any
Without any.
condition.
That is there, but my lord, due to this observation, my lord, tribunal, my lord, the registry, my lord, deposited totally 50.
Stop. Out of the 50% of the awarded amount to be disbursed to the claimant. Rupees, how much?
My lord, 3,10,000.
How much you are ready?
Hello?
How much you are ready to deposit?
75,000, my lord.
1 lakh.
My lord, otherwise also it's 1 lakh, my lord, as per the tribunal judgment.
An amount of rupees 75,000 shall be deposited in fixed deposit in the name of the claimant for a period of 2 years from the date of such disbursement. This application is accordingly disposed of. What happened in appeal?
By the appeal is a response number 2 is the owner of the vehicle. So as per office note dated, my lord, 24/7/26. This not trace out. There is no address is found. So I mean, she is, my lord, awaiting for the service report. My lord, fixed on 3rd of July, September. Take the instruction from the court.
Okay, heard Mr. R.C. Paul, learned counsel for the applicant, as well as Mr. M. Datta, learned counsel for the respondent slash claimant. The service report in respect of notice issued to the respondent number 2 and 3 are away. 3 is awaited. Await further. Let this matter be listed on
11th of September.
11th of September.
Obliged.
Okay.
My lord, in next case only notice will issued, my lord. Delay continuation. First time.
For reasons mentioned in the judgment, both the appeals as well as cross objection are partly allowed. The compensation awarded to the claimants is enhanced to rupees 9,02,000 along with an interest at the rate of 9%.
Item 54.
54 and 55. 54 and 5, it will be delivered on Thursday. Thursday, 27.
56.
56. For reasons mentioned in the judgment, this CRPIO is dismissed. And the stay of suit granted earlier is vacated. For reasons mentioned in the judgment, the impugned judgment of the trial court, whereby the appellants were convicted and sentenced under Section 20B2C of the NDPS Act, is hereby set aside, and the appellants are acquitted of charges under the above sections. They are directed to be set at liberty forthwith, if not required in connection with any other case.
Hello.
Heard Mr. S.K. Ghosh, heard Mr. F. Ahmed, the learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant, praying for condonation of delay of 38 days in filing the connected appeal. Issue notice to the opposite parties. Stop. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th September.
Deeply obliged.
Listed for the first time also.
This is condonation,
Correct.
same order, KK Bhutto. And date is same.
But
Yes.
kindly see the office note to the 12/6/2026, let's say.
12/6.
Step was taken by register coach as usual manner, let's say. And the same was issued on 9/6/2026.
You are for
1 to 3, respondent one. LCR had already received.
12/6. You were directed to take fresh steps.
Let's see. As per the order dated 18/5/2026, let's see. Step was taken on 9/6/2026, let's say.
Yes. No, but thereafter by
But
12.
that was not pointed on earlier date, let's say. That is why, let's say.
No, no. It was pointed out. It is mentioned that the service report has not come in respect of notice issued to 4 and 5. Due to lapse of long period, you were directed to take fresh steps.
Since 1 month at the time that at the time was not
9, 6, 7, 8.
9/6/2026, let's say. Step was taken. 6.
Okay, let us see. Third, Mr. KK Bhatto, the learned counsel for the appellant. Also heard Mr. A. Khan, appearing for respondent number 1, 2, and 3. Learned counsel for the appellant has submitted that the office note dated 12/6/2026 reflects that the present appellant has taken steps for issuance of notice on respondent number 4 and 5 by speed post on 9/6/2026. He submits that since 3 months have not yet lapsed, the registry may be directed to place the postal track consignment report of the notice issued to respondent number 4 and 5 by speed post. The prayer is allowed. The registry to place the postal track consignment report of notice issued to respondent number 4 and 5 by speed post on 9/6/2026 before this court on the next date fixed. Let this matter be leave. No, before 7th of September.
Supremacy. SL, SL, SL 61, SL. My lord, this is an appeal, my lord, filed against order dated 59/2023, passed by the Honorable MSCT North Lokhimpur, my lord. My lord, this make appeal is not for any enhancement, my lord. My lord, initially after filing the MSCT case, my lord, due to the COVID-19 period, the date was unknown to the appellant. Therefore, the MSCT case was dismissed, my lord. And later on, my lord, we had filed a delay condon petition along with a restoration petition, my lord. My lord, delay condon petition was allowed as the Supreme Court, there is an order to exemption of the period of COVID-19. And that delay condon petition was allowed,
but restoration petition was not allowed. Only on one ground that, my lord, the engaged advocate was not present on the date of order. My lord, see the page number 23, my lord. Page number 23, Annexure F, my lord. My lord, petitioner is represented, but opposite party number 1 and 2 was absent. The case was fixed, the case has been pending for final order, my lord. On 25/7/2023, OPs number 1 and 2 were represented, but petitioner was absent. Therefore, on 7/8/2023, both the parties was absent. Today, the petitioner is represented, but the OP number 1 and 2 are absent. On the last date, it was stated that the order that the case be fixed for final orders today, so that the final order may be passed in the presence of the parties. As the OP 1 and 2 are absent today, I deem fit proper to fix a date for hearing for the both parties on the next date fixed. And next date was fixed for 15/9/2023. My lord, on the date of 19/8/2023, the petitioner side was present. But my lord, unfortunately, on the date of 15/9/2023, on that day, petitioner side was not present. Therefore, the registration petition was dismissed, my lord. My lord, as the delay condone petition was considered and the petitioner for the claimant was present on the last date, but on the date of order, it is mentioned then on the last 4 dates was absent. But on the previous date, the petitioner side was present, on which the final order was fixed, my lord. So, my lord, as the claimant is very much poor, my lord, she is a physical handicap. As the MSC case is welfare legislations and therefore considering the grounds, maybe allowed to restore the case and directed the court to take the matter as specific.
Where is the,
My lord, I have.
where is the impugned order?
My lord, page number 24. Page number 24, Annexure G. Well, due to that accident, the petitioner is physically handicapped, my lord. We have obtained a certificate also. And as the delay in respect of filing the restoration petition before the trial court matter, it was not intentional, my lord. Due to the COVID-19 period, it was delayed, my lord. So that was also considered, but restoration petition was not considered. Only one ground, then the petitioner side was absent.
Heard Mr. B. R. Das, the learned counsel for the appellant. On perusal of the office note dated 2, you have taken steps.
Yes, my lord. Notice is completed, my lord.
Office notes. It appears that the notice issued to respondent, no, on perusal of the order dated 5/2/2026, it appears that notice issued to respondent number 2 has been held to be duly served by this court on that day. And as regards notice upon respondent number 1, B, appellant has submitted the affidavit in compliance regarding publication of the notice in the newspaper as was directed by this court. On perusal of the affidavit as well as the newspaper annex therewith, it appears that this court is of considered opinion that the notice on respondent number 1 may be held to be duly served through substituted mode. This appeal under section 173 of the Motor Vehicles Act has been filed by the appellant impugning the order dated 15/9/2023 passed by the Motor Accident Claims Tribunal number 1 Kamru Metro in MEC case number 1/2018, whereby where is the application on?
Restoration application, my lord.
Yes.
My lord, restoration petition, page number 16 to 19, my lord. Page number 16 to 19.
Whereby the application filed by the present appellant under Order 9, Rule 4 of the Code of Civil Procedure for restoration of MAC case number 6/19 was dismissed. Learned counsel for the appellant submits that the impugned order of dismissal of Miss case number 4/2023 was passed by the tribunal due to absence of the engaged counsel of the petitioner before the court on that day. He submits that the petitioner's counsel was present before the tribunal on 19/8/2023. However, on that day, the opposite party number 1 and 2 were absent, and as such, the case was fixed by the tribunal on 15/9/2023. He submits that. Why you lapse defaulted on 15/9?
15/9/2023, my lord, on the day the advocate was busy in another court, my lord.
Can this be a just ground?
Yes, it was not also informed, my lord.
He submits that on 15/9/2023, the engaged counsel for the, who was the counsel?
My lord, myself.
Then you pay a cost to the petitioner. We are allowing this appeal. You have to, you have yourself committed lapse.
Yes, ma'am. I apologize for that, ma'am. Sorry.
Apology will not suffice. You pay a cost of rupees 5,000 to the appellant. On that ground, we will be allowing. क्या लिखा? Engage counsel for the petitioner was busy in some another court. Stop. Surprisingly, the present engaged counsel for the appellant was the engaged counsel for the applicant before the tribunal in Miss case number 4/2023, and the lapse committed by him has been fairly admitted by him. Stop. It appears that the Miss case number 4/2023 was not dismissed by the tribunal on merit of the case, but only due to the default of the engaged counsel of the petitioner to present himself before the tribunal when the matter was called. Apparently, there appears to be no lapse on the part of the present petitioner, but the apparent lapse on the part of the engaged counsel for the petitioner is there. In Miss case number 4/2023. As such, this court is inclined to allow this appeal and set aside the
Both the order, my lord, dismissal order dated 11/3/2020 as well as
no 11/3/2020, that will be considered by that court. Only this 15/9/2023.
yes.
क्या लिखा? And set aside the order dated 15/9/2023 passed by the Motor Accident Claims Tribunal, Lakhimpur, in Miss case number 4/2023, subject to payment of a cost of rupees 5,000 by the engaged counsel, Mr. B.R. Das, to the petitioner. To the petitioner of Miss case number 4/2023 before the tribunal. The tribunal shall hear the application filed by the present appellant under Order 9, Rule 4 of the CPC, after affording opportunities to both sides, and thereafter decide the matter on merits. This appeal is accordingly disposed of. Let a copy of this order be furnished to the Court of Additional District Judge within bracket FTC, come member MACT Lakhimpur by the registry of this court.
Made business, your lordship. Lordship, here we have taken steps only on 21/8/2026, lordship, on respondent number 5 and 6. So we have to await service report.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. J.U. Ahmed,
1 and 2.
learned counsel for respondent number 1 and 2. Though the office note dated 28/2026 shows that steps for issuance of notice upon respondent number 4 and respondent number 5 have not been taken, however, the learned counsel for the appellant submits that the steps were taken on 21/8/2026. Stop. As such, the registry is directed to furnish the postal track consignment report of notice sent to respondent number 4 and respondent number 5 and 6 before this court on the next date fixed. This matter on 16th of September.
Highly obliged, lordship. 63, lordship.
Yes.
63, lordship, office note dated 21/8/26 shows that postal tracking for R4 still in transit and respondent 5 delivered.
He has appeared for respondent number 5.
You are appearing
1,
for
2, and 3.
heard Miss R.D. Majumdar, the learned counsel for the applicant. Also heard Mr. A. Das,
Only one person is left.
the learned counsel for, sorry, A. Bishwas, the learned counsel for respondent number 1, 2, and 3, as well as Mr. What is your name? F.L. Oscar, appearing for respondent number 5.
Only the owner is left, I think.
Otherwise, this is a delay petition, lordship.
We'll fix a short date.
This short date may be fixed because I think as per the
Office
both of
note
them are owners.
Office note dated 37/2026 shows that service report in respect of notice issued to respondent number 4 is awaited. The registry is directed to place the postal track consignment of notice issued to respondent number 4. Again, before this court on the next date fixed. Let this matter be listed 9 September.
Highly obliged, lordship.
As per office note dated 28/26, notices were sent to the respondents 2 and 3 by usual process. But we failed to take steps by speed post.
Now take steps.
Yes,
Lordship, I am appearing for respondent number 1. Your lordship, the appeal memo has been served today only, so it may be recorded that the appeal memo has been served today.
Okay. Heard Mr. A.J. Sakya, the learned counsel for the appellant. Also heard Mr. D. Mondol, the learned counsel for respondent number 1, who submits that he has received the memo of appeal today only. It also appears from office note dated 21/8/2026 that service report in respect of notices issued to respondent number 2 and 3 is awaited. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post within 7 days from the date of this order, returnable on 16 September.
Oblige, your lord.
Although the last two occasions have sought time, the filer objections, one. Because due to the multiplicity of litigation, I second the same cause of action, my lord. Here's awaited some documents are awaited. We are seeking only 1 week time to file our objection.
Heard Miss V. Rai, the learned counsel for the appellant slash applicant. Also heard Mr. S. Bharali.
M. Smith.
Sorry. Also heard Mr. M. Smith, learned counsel for respondent number 1 to 5, who seeks some more time for filing written objection in the interlocutory,
In detail.
in the connected interlocutory application. The prayer is not opposed to by learned counsel for the appellant.
Should the interim order pass or
Hence,
maybe extend?
same is allowed.
Any date may be fixed.
Let this matter release 16th of September. The
Lordship-
interim order granted shall continue till next day. Granted earlier shall continue.
Item 4.
Wait, your lordship. Lordship, I have filed this first appeal, lordship, against the order passed by the special tribunal, lordship, land grabbing, lordship. Lordship, may kindly turn to page number 36 of the appeal memo, lordship. 34, lordship. In this case, what has happened, lordship? I am the owner of the land, and adjacent to me there is a brick lane, and the owner of the brick lane, he has dumped some soil in my land, and he has refused to remove it, and then now he is trying to build a house, semi RCC or kacha structure there. So that is the case, lordship. On the basis of this, lordship, I have filed a land grabbing case, and this is the order passed by the special tribunal in page number 34 with regard to the land grabbing case, lordship. Lordship, I'll just read it, lordship. Received the case record. The case has been registered on the basis of an application filed by the petitioners Arvind Kumar Bidauka, Suman Devi, Ayush and Archit under the provisions of Assam Land Grabbing Prohibition Act 2010. The petitioners Ayush Kumar Bidauka has also filed his initial depositions in the form of an affidavit. Heard and perused. It appears that the applicants are the owners and possessions of the plot of land measuring 13 bighas 2 kathas covered by DAG number 1297 and patta number 22024 of village so and so Palashbari so and so on 31/7/2026, and on a few dates thereafter, the respondent number 1 Sarad Das, who has a brick lane in the land adjacent to the land of the applicant, tried to grab the land of the applicants. Hence, cognizance of the case is taken. Let notice be issued to the respondents. Applicants shall take steps fixing 25/9/2026 for SR and objection. So, lordship, cognizance has been taken under land grabbing and specifically stating that I am the owner of the land. Now, lordship, may kindly come to page number 36, lordship. This is, I have filed an application for injunction, lordship, and that this is the order passed in the injunction petition, lordship.
Yes.
Lordship, I'll skip the first first two paragraphs, and I'll start from page para number 3, page number 36.
Yes.
It appears that the petitioners are the owners and possessors of the plot of land measuring so and so. It has been submitted on behalf of the petitioners that on 31/7/2026, the OP Sarad Das, who has a brick lane in the adjacent land to the land of the applicants, dumped huge quantities of soil on a portion of the petitioner's land. He has also erected a temporary shed with conjuncted sheets. Even after repeated requests from the petitioner's side,
the OP number 1 had not removed the soil and the temporary shed. On 9/8/2026 and on 10/8/2026, the OP and his men forcefully dug a few craters on the land and unloaded lots of bricks on the said land. The OP has grabbed a portion of the applicant's land. The petitioners have filed this injunction, this application under the provisions of Assam Land Grabbing Prohibition Act 2010. In the present proceedings, the petitioners have prayed for an ad interim injunction restraining the OPs from disturbing the peaceful possession of the petitioner's land and restraining the OP number 1 from undertaking any construction activities over the scheduled land. A prima facie case appears to exist in favor of the petitioners. If the OP is allowed to continue construction work over the petitioner's land, it is likely to cause irreparable loss to the petitioners. Balance of convenience also appears to tilt in favor of the petitioners, and if the OP is prevented from dumping soil and constructing over the land, no inconvenience is likely to be caused to the OP. Now, till here, everything is fine. The learned court below is in favor of me. Now, Lordship, what he has done, Lordship, in view of the above, the OP number 1 is directed to restrain from dumping soil and undertaking any construction work over the scheduled length till the disposal of this case. The petitioners also shall not undertake any activity, Lordship. How can this be, Lordship? Undertake any activity over the disputed land till this tribunal adjudicates on the civil liability of the parties. Apparently, the scheduled land is not in possession of any of the disputing parties. From where, Lordship? He has taken cognizance of the case under land grabbing, saying that I am the possessor of the land and owner of the land. Now he is saying that apparently the scheduled land is not in possession of any of the disputing parties. Lordship, this is beyond the record. And none of them shall make any attempt to process the land till disposal of this proceeding, inform accordingly. Now, I am aggrieved by this portion, Lordship. The conditions imposed on me. I have filed a land grabbing case. It is my land. I have shown prima facie establishes that it is my land. How can he injunct me from going into my land? Okay. Now, Lordship, there is one more aspect of this matter which has been done by the learned court below. Lordship, may kindly, I'll just read it over again, Lordship. The petitioners shall not undertake any activity over the disputed land until this tribunal adjudicates on the civil liability of the parties. Lordship, I am heavily objecting to this, Lordship. Now, why I am saying so, Lordship? Lordship would kindly take up the Land Grabbing Act once, Lordship. There's a printout copy provided for your Lordships.
Yes. Yes. Yes.
Lordship, as per the Land Grabbing Act, a procedure has to be followed, which is mentioned in Section 10 of the Land Grabbing Act, Lordship. May I just read it, Lordship?
Yes.
Save and otherwise provided in this Act, a special tribunal shall, in trial of a case relating to any alleged act of land grabbing or with respect to ownership and title to or lawful possession of the land grab, whether before or after commencement of this Act, which involves civil liability, follow the procedure prescribed in the Civil Procedure Code, Code of Civil Procedure, and in the trial of the case relating to alleged offence, the land grabbing involved punishment prescribed under the Act, follow the procedure of Code of Criminal Procedure. So, Lordship, this has come, the civil liability first part has to be decided first, Lordship, and then with respect to whether there is a commission of crime, Lordship, CRPC has to be seen, Lordship. Now, Lordship, the learned court below has automatically tried to engage in a question whether I am entitled to title. That means the civil liability, which your Lordship, as a division bench of this honorable court, has already held that he cannot do that. Lordship, I'll just refer to this judgment. Lordship, the division bench of this honorable court, Lordship, a question with regard to the maintainability of the Act has been challenged, Lordship. So answering to this particular question, Lordship, the last portion, Lordship, para number 23.2, if Lordship has got it, last page, Lordship, second last page.
Yes.
Regarding second part of the question, we have already elaborately discussed above. The core object of 2010 Act is to prohibit and punish land grabbing. The Section 10 Act is a special legislation dealing with a special problem which was assumed endemic proportion. It seeks to ensure dispensing of speedy justice to the victims of land grabbing by evolving a special procedure. In course of inquiry and trial by the special tribunal regarding the offense of land grabbing, if the alleged land grabber puts up a defense of proprietary right or ownership or possessory right over the land in question, then only the special tribunal shall embark upon a summary adjudication of the civil liability first. Adjudicating of the civil liability once cognizance of the offense of land grabbing is taken is not automatic. A special tribunal is not obliged or required to embark upon the exercise of determining defense is set up by the accused civil liability in each and every case of land grabbing inquired into and tried by it. It is only when a plea is taken or a defense is set up by the accused that he has a better civil claim over the land in question that the special tribunal shall carry out determination of the civil liability, which is for a limited purpose to ensure that the accused is not wrongfully prosecuted, where the burden would be on the accused to prove otherwise. This would be in consonance with the underlying principles governing Section 11 of 2010 Act. However, if in a given situation, notwithstanding the plea or defense taken by the accused of having a better claim over the land in question, the special tribunal proceed with the criminal proceeding of the accused at that stage, and the same is brought to the notice. It may keep in abeyance the criminal prosecution and take the defense of plea of civil liability. After determining the said question in a summary manner, if the determination is in negative, so far as the accused is concerned, the special tribunal shall recommence the trial or criminal trial at once. So this
In
is
the
the
instant case, the other side has not yet appeared.
not yet appeared. He has to come and say, this is not my, this is my land. Only then this will come, Lordship. Lordship, I may humbly, may I just submit one thing, Lordship? Notice, I have already taken steps as per Order 39, Rule 3, Lordship. Lordship, whether a notice has to be sent to the opposite party in this case also, because apparently, Lordship, this entire observation and with regard to curtailing my right of entry into my land is absolutely illegal. He cannot do it automatically. And he himself has contradicted himself. He has come to a specific finding that I have a prima facie case because I'm the owner of the land.
Change.
So Lordship may stay the portion, that specific portion, or Lordship may strike down the specific portion and revert the matter back, Lordship, if it is permissible, Lordship. Because again, I will again have to take steps on the opposite party. Again, they will contest here, and then again the court that specific thing is already running. The date fixed is on 25/9.
Okay, the other side has not yet appeared.
Not yet appeared, Lordship.
Whether you have taken steps.
Yes, Lordship, I have within 24 hours, which is the mandate of Order 39, Rule 3, Lordship, I have complied with
When
that.
is the date fixed?
25/9, Lordship, as it has been pointed out here.
Tomorrow.
25/9, Lordship.
25/9. Okay. Heard Mr. P. Deka, the learned counsel for the appellant. This appeal under Order 43, Rule 1 within bracket small r of the Code of Civil Procedure has been filed by the petitioners impugning the order dated . 13/8, order dated 13/8/2026, passed by the Court of Learned, Additional District Judge. What tribunal it is known as?
The Land Grabbing Special Tribunal, Lordship.
Land Grabbing Special Tribunal in Ms. J case number 27/2026, arising out of Special Land Grabbing case number 9/2026. The facts relevant for consideration of this appeal, in brief, are that the present appellants have filed a Where is the petition?
Lordship, I have filed two petitions, Lordship, one for stay and the other for injunction, Lordship. That IA number 2981 is for injunction, Lordship. And IA number 2980 is for stay, Lordship. Stay of the impugned order, Lordship.
What injunction you are seeking?
Lordship may only strike down that portion, Lordship. Then Lordship, may IA number 2980, Lordship, that is for stay. That is where I have pleaded, Lordship.
Common order. IA, in IA as well as in the appeal. Huh? Two IAs and appeal common. This main land grabbing case number 9 was filed under what provision? 8(2).
8(2), Lordship. 8, Lordship. I'll just.
Have filed an application under section 8 within bracket 2 of the Assam Land Grabbing Prohibition Act 2010, read with Rule 3 within bracket 1 of the Assam Land Grabbing Prohibition Rules 2013, inter alia alleging that the petitioners are the absolute owners and possessor of a plot of land measuring 13 bigha 3 kathas covered by dag number 1297 in KP Pata number 2024 under Moja Rampur in village Nahira under Palasbari Revenue Circle in the district of Kamrup, Assam. It is alleged that the present respondent, there are 3 respondents. Which
I will the 2 and 3 are pro forma, Lordship. They are the original owner of the land, but this person is
present respondent number 1 had started dumping soil from his brick kiln, which is situated adjacent to the said land, and has illegally constructed a tin chali on the top of the dumped soil. It is further alleged that the respondent has also dug big holes in the southern portion of the land in order to erect RCC pillars and to build boundary walls. The learned counsel for the appellant has submitted that the said case was registered as land grabbing case number 9/2026 before the special tribunal stop. He further submits that in the aforesaid case, the applicant, the present appellant, has also referred in, has also filed an application under Order 39, Rule 1 and 2 of the CPC, read with Section 15 of the CPC, praying for grant of temporary injunction against the respondent during the pendency of the special land grabbing case number 9/2026. Stop. The said case was registered as MISJ case number 27/2026. Stop. The learned counsel for the appellant further submits that by order dated 13/8/2026, passed in special land grabbing case number 9/2026, the Court of London Additional District Judge cum Special Land Grabbing Tribunal, Special Tribunal had taken cognizance of the case and issued notice to the respondents. He further submits that in the connected MISJ case number 27/2026 also, the notices were issued to the opposite parties. However, while issuing notice, as prayed for by the present appellant, the opposite party number 1, namely Sarad Das, was restrained from dumping soil and undertaking any construction work over the scheduled land till the disposal of the connected land grabbing case. Stop. Learned counsel for the appellant has submitted that the appellant is aggrieved with the observations made by the special tribunal in second part of the para number 6 of the impugned order dated 13/8/2026, passed in MISJ case number 27/2026. He submits that the tribunal, while restraining the opposite party and while issuing notice to them in the MISJ case number 27/2026, also injuncted the present petitioner not to undertake any activity over the disputed land until the tribunal adjudicate the liabilities of the parties. He further submits that tribunal also made a observation, without any material on record to that effect, that the scheduled land is not in possession of any of the disputing parties. Stop. He submits that while making the said observation and injuncting the present appellant, the tribunal exceeded its jurisdiction under section 10 of the
Assam Land Grabbing Prohibition Act 2010.
Assam Land Grabbing within bracket Prohibition Act 2010. He submits that as per the scheme of the said act, as clarified by this court, as clarified by a division bench of this court in a reference made to it in the case of XXX versus State of Assam, reported in 2018 2 GLR 313. The question of adjudicating the civil liability after taking cognizance of offense of Land Grabbing Act would arise only if the alleged land grabber puts up a defense of proprietary right or ownership or possessory right over the land in question. Stop. Only in such a circumstance, the special tribunal shall embark upon a summary adjudication of civil liability first. Stop. The learned counsel for the appellant submits that in the instant case, only the notices have been issued to the respondent number 1, and next date is fixed on 29th of 25th of September 2026, and the respondent side is yet to appear before the special tribunal. Therefore, the question of putting a defense by the alleged land grabber on the date when the impugn order was passed does not arise. He submits that the special tribunal has erred in taking upon itself the adjudication of civil liability without there being any plea from the respondent side regarding plea disputing the ownership or possessory right of the present appellant over the scheduled land. Hence, he submits that the impugned order to the extent it has directed the present petitioner to
not to undertake
any activity over the disputed land is apparently beyond its jurisdiction. Stop. Hence, he submits that the said observation made by the
And Lordship, also that I'm not in possession of the scheduled land, Lordship.
said observation, no, क्या लिखा? ना उससे पहले. Stop. He further submits that the observation made by the tribunal that the petitioner is not in possession of the disputed land is also without any basis, and as such he prays for setting aside the impugn order to the extent it has directed the present petitioner not to undertake any activity over the disputed land, as well as the observation made by the tribunal without any basis regarding the fact that the present appellant is also not having possession over the scheduled land. He submits that since the respondent is yet to appear before the special tribunal, as next date is fixed on 25/9/2026. Hence, instead of issuing notice in this appeal may be, the case may be remanded back to the special tribunal by striking out the observation made in paragraph number 6 of the impugn order, wherein it has directed the present appellant not to undertake any activities or disputed land, as well as the observation that the scheduled land is not in possession of the present petitioner, as same would save sufficient judicial time. Stop. I have considered the submissions made by learned counsel for the appellant. Apparently, the procedure to be followed by a special tribunal in land grabbing case has been laid down by the division bench of this court in the judgment in case within inverted comma XXX versus State of Assam, Supra. Wherein the division bench of this court has categorically observed that the mere taking of cognizance in taking of cognizance of offense in a land grabbing case would not automatically oblige the special tribunal to embark upon the exercise of determining civil liability. Stop. It observed that it is only when a plea is taken or a defense is set up by the accused that he has a better civil claim over the land in question, that the special tribunal shall carry out determination of civil liability, which is for the limited purpose to ensure that the accused is not wrongfully prosecuted, where the burden would be on the accused to proving otherwise. Thus, in a land grabbing case, the question of adjudicating civil rights between the parties would arise only if such a plea is taken by the land grabber. However, in the instant case, only notices have been issued to the respondent / alleged land grabber, and he is yet to put his defense before the special tribunal. As such, apparently, the observations made by the special tribunal in second part of the paragraph number 6 of the impugned order, that impugned order, whereby apparently it has embarked upon adjudicating civil liabilities of the parties even before the land grabber putting up any defense or plea, and in that regard. Stop. As the act of the special tribunal is apparently beyond jurisdiction, this court is not inclined to issue notice to the respondent in this case and set aside the observation made by the special tribunal in the paragraph number 6 of the impugned judgment, namely as impugned judgment. Stop. The observations and the directions which are hereby set aside are observation and directions which are hereby set aside are as follows, within inverted comma. The petitioner shall also not undertake any activities over the disputed land until this tribunal adjudicate on the civil liabilities of the parties. Stop. Apparently, the scheduled land is not in possession of any of the disputing parties, and none of them shall make any attempt to possess the land till disposal of this proceeding in form according the inverted comma clause, all in italics. The above observation is hereby set aside, and the matter is remanded, and the case is remanded to the special tribunal to proceed in accordance with law by following the procedure as laid down by the division bench of this court in the case referred herein above.
Lordship, and that injunction which is granted is still.
That will remain, only that it is hereby clarified that only the portion quoted herein above of paragraph number 6 of the impugned judgment, impugned order is hereby set aside, The remaining part of the impugned order shall continue to have force and be valid. Stop. With above observation, anything else? With above observation, this appeal as well as the connected interlocutory applications are disposed of.
Highly agree, Lordship.
Item 5.
Yes.
May I please, your lordship?
Yes.
Lordship, in this matter, Tata Wingard and Tata Truck collided, and due to that accident, Dhubri MSC Tribunal awarded that both the vehicles were at fault, and national insurance has to pay for both of them. But whereas Tata Truck was not under national insurance policy. Even witnesses were given for that.
You are for national insurance?
Yes, Lord.
Okay. Heard Miss D. Hajorika, the learned counsel for the appellant. Also heard Mr. A. R. Agarwala, appearing for respondent number
Respondent number, element 1 and 2.
1.
1 and 2.
1 and 2. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and award by award dated 29/6/2024 in MEC case number 146/2016, passed by the Motor Accident Claims Tribunal, Dhubri, in which only you were directed, in which the
Lordship, both the vehicles were issued with the national insurance.
they are denying, in which the present appellant was directed to pay a compensation amount of rupees 31,10,000 along with an interest at the rate of 7% per annum to the claimant. Stop. I have gone through the grounds stated in the memo of appeal, as well as considered the submissions made by the learned counsel for the appellant. Stop. This appeal is admitted. Stop. Let the records of MEC case number 146/2016 be called for from the concerned tribunal. The registry shall take steps for requisitioning the said records. Stop. Let also the notice be issued to the respondent. Since Mr. A. R. Agarwala has already appeared for respondent number 1 and 2, no formal steps for issuance of notice is required to be taken against said respondent. However, the appellant shall furnish requisite numbers of copies of memo of appeal along with annexure to the learned counsel for the respondent number 1 and 2 within 2 days from the date of this order. As regards other respondents, the appellant shall take steps for issuance of notice to them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of September.
Sir, stay is also there.
Stay, they are not pressing.
Stay.
We are issuing notice.
No, Lordship, they were willing to deposit that their liability of the injured vehicle.
You are willing,
We are ready to pay for the wingard.
That means 25%.
how much liability was imposed?
25%.
How 25%?
Lordship, that is 30 lakhs and two vehicles are involved, but we are saying that both the vehicles are insured with them only, but they are willing to pay 25%.
What was the extent of liability of each?
Their liability is full, Lordship.
No, 50-50. Wait.
If I may just help her,
Hello.
no issue. Lordship, what she
truck
is submitting is that two vehicles were involved, so 50% each. And now if they have to deposit 25% of that, 50% of that 50%, that will be 25% of the total amount.
Lordship's truck was not insured under national insurance. Only wingard was insured.
Okay, that is your claim. You are ready to deposit 25%.
Yes, Lordship, for the wingard.
Heard Miss D. Hajorika, the learned counsel for the applicant insurance company. Also heard Mr. A. R. Agarwala, the learned counsel for the claimant opposite parties. This interlocutory application has been filed by the applicant insurance company in connection with MSC appeal number 203/2026, praying for stay of execution of the impugned judgment and award dated 29/6/2024, passed in MSC case number 146/2016 by the Motor Accident Claims Tribunal, Dhubri. During the pendency of the connected MAC appeal number 203/2025. Stop. The learned counsel for the applicant insurance company has submitted that the applicant insurance company is agreeable to pay 25% of the awarded amount as a condition for grant of stay of the impugned judgment and award during the pendency of the connected MAC appeal. Stop. The learned counsel for the opposite party / claimant does not have any objection with the same. As such, notice to other opposite parties in this interlocutory application is hereby waived, and this interlocutory application is allowed. The execution of the impugned judgment and award dated 29/6/2024, passed in MSC case number 146/2016 by Motor Accident Claims Tribunal, Dhubri, shall remain stayed during the pendency of the connected MAC appeal number 203/2026, subject to deposit of 25% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. Stop. On such deposit being made, same may be disbursed to the claimant number 1 by the registry after proper verification. With above observation, this interlocutory application is disposed.
May it pleases your lordship, this appeal is filed, lordship, because it was a hit and run case. As per the FIR, GD entries were exhibited by the appellant company, and as per the FIR also exhibited by the claimant, lordship. another unknown vehicle had caused the accident. So that is our main ground. Other than that, Lordship, also on quantum, we have a few grounds on quantum.
Okay, appeal may be admitted, my lord, subject to deposit of 50%.
Lordship, hit and run case,
No.
Lordship.
But I will satisfy, my lord, why it is not a hit and run case.
That will need the hearing.
No, no, my lord, law is very settled, my lord. Here, my lord, as per her version, my lord, two vehicles are involved, my lord. One unknown vehicle, one is, my lord, motorcycle, my lord.
That question will come in the IA.
Not in the appeal.
I'll admit the appeal.
But my lord, they cannot both together, my lord, because after all, it's a money decree, my lord.
No,
Blanket stay,
It
my
is
lord,
a
it's not an
statutory-
exceptional, my lord, case, my lord.
It is
where
a statutory
blanket stay can
appeal,
be-
Lordship.
stay. I'll consider your submission while taking up.
Yes, then,
interlocutor. But appeal has to be admitted. Heard Miss Adi Majumdar, the learned counsel for the appellant. Also heard Mr. N. Datta, the learned counsel appearing for respondent number,
one, my lord.
respondent number 1/claimant. This appeal under section 173 of the Motor Vehicles Act has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 18/11/2024 passed by the Motor Accident Claims Tribunal, Golaghat, in MSC case number 17/2018. I have considered the submissions made by learned counsel for the appellant, as well as gone through the memo of appeal. Stop. This appeal is admitted. Let the records of MAC case number 17/2018 be called from concerned tribunal. The registry to take steps for requisitioning the records. Let the notice be issued to the respondents. Since Mr. Datta has already appeared
Copy
for
served, Lordship.
respondent number 1, no formal steps for issuance of notice is required to be taken against the said respondent. Stop. Again, as against the remaining respondents, the appellant shall take steps for issuance of notice upon respondent number 2
By speed post only, Lordship, because the other one is futile.
by speed post. By speed post. Within 7 days from the date of this order, returnable on 25th of September. List accordingly. Now, yes, now what is the submission?
Lordship, even if Lordship directs us to deposit, Lordship, but withdrawal, we should have a hearing, Lordship. They have to file a IA for withdrawal.
No, my lord.
We have to have otherwise we are not pressing
My
at this time.
My lord, let her argue, my lord. Let her argue, my lord, on what point, my lord, I am not at all entitled to withdraw the 50%.
Our alternative submission is that they may not press the IA.
My lord, may kindly appreciate one thing, my lord. After all, it's a money decree, my lord. And there is not an exceptional case. This is not an exceptional case where a blanket stay can be granted.
No, we will not grant any stay. No stay.
But my lord, may kindly appreciate one thing. My lord, as per her submissions, my lord, two vehicle, my lord,
No,
is
no.
involved in this case. No, let me, my lord, place my facts, my
We
lord.
will not enter into merit. If
No, I am not entering into the merit, my lord. I am just
listen to me.
petition, my lord.
She is not making any submission. She is saying that she will not pray for stay. So you go.
She said she has submitted, my lord, she has deposited 50%, but I am not allowed to withdraw it. That is her submission, my lord.
No.
It is
If
her
you,
submission.
if it is to be, then I'm not pressing.
She's
No.
not,
I'm not pressing.
My lord, it's a case
will
of.
not grant any stay. We will not grant any stay. You file an execution proceeding.
No.
You are open to take mere admission of appeal does not mean a stay.
No, but my lord, she has already, my lord, submitted. And my lord, along with this, my lord, IA is filed, my lord, for stay the proceeding, my lord.
You pray for dismissal of the IA, will dismiss the IA.
That is, my lord, I am not praying for dismissal, my lord, because, my lord, it's a, my son expired, my lord, way back on 2017, my lord.
But
And I
someone
am
makes
not
a
a-
fraudulent
no,
claim
no,
that
no
any
fraudulent
vehicle was
claim, my lord. It's not a
vehicle was
fraudulent claim.
involved when that vehicle was not even involved,
no,
Lordship.
no,
It's a hit and run
No,
case.
my lord,
If
after
she is
judgment, my
not, if she is not pressing for the
No, no, she
stay,
has
we
not
will
said
dismiss it.
said so. She has said, submitted, my lord, if they may be directed to deposit, but I may not be allowed to withdraw. Because as per her contention, my lord, two vehicles.
Yes,
involved.
Ms. Majumdar, what is your submission?
Yes.
I'm not pressing because there is so
Now
much
she
of
is not
argument.
pressing, my lord.
There is so much of argument as if it is a final hearing, and he is pointing that I should do the argument on the merit of the case,
no, my
Lordship.
lord.
So let it be there.
My
Let
lord, that's
the
the difficulty, my lord.
party appear. Let the
That's the
SPR
difficulty,
come.
my lord.
I'm ready to do the hearing even in September. No issue with that.
It will not.
Because we proved our case, the court has not looked into that.
No, my lord.
That is our.
No, my lord, law is very
Their
simple. My lord.
own
In case of
document.
involvement of two vehicles, my lord, claimant has the prerogative to whom they made
It is not
the
two
party, my lord.
vehicles.
Because, my lord, Supreme Court is Kenya case, my lord, is very clear, my lord. Paragraph 22, 1 and 2, my lord.
No, Mr. Datta.
No, my lord, may kindly
Listen to,
decide it, my lord.
listen to me. If they are not pressing,
No, they have already submitted, my lord. Then
now she is submitting, she is not
then,
pressing.
my lord, now, my lord,
I'm this,
lordships, my lord, she is.
why don't you go for 100% execution?
100% will not possible, my lord, within a short span of time, my lord.
Why?
Because, my lord, as today, my lord, as the lordship has admitted the appeal, then LCR will take some time. Then when the LCR will come, it will come to the downside of the cause list, my lord, in the hearing column, my lord. So there is a very big chance.
No,
of
where is
getting
the difficulty? Where is the difficulty in going for execution before the tribunal?
No, my lord, there is no such case at all, my lord. Only because of her submission, my lord. My lord may go through the grounds of appeal, my lord.
No, if somebody is not praying for stay,
No, but my lord,
this court is not inclined.
appreciate one thing, my lord. It's a beneficial legislation, my lord.
Therefore, I am saying,
My lord, we are not, my lord, I am very much entitled to 50% of that, my lord.
you are entitled to 100% if there is no stay. If there is no stay, then you are entitled to get 100%. If they
No,
win
my
the
lord,
case,
my lord, may kindly hear with me for two minutes, my lord. If I fail to satisfy your lordship, then
yes.
my lord may kindly see, my lord. As per her submission, my lord, this case, but two vehicles are involved. my lord. One unknown vehicle.
Stop. I'm not going into merit.
Yes.
No, that's not a question of merit, my lord.
Merit of the IA. Merit of the IA. I will dismiss the IA now. She is not pressing the IA. I will dismiss the IA. You go for the execution. I'll make it clear. You are not pressing for IA.
Because
No,
fraud is involved, Lordship. I
not
cannot
fraud,
press
my
for
lord.
when
My lord,
there is a that
two vehicles
we
involved,
have
my
to
lord.
deposit and they have to
Bear
withdraw,
with me
Lordship.
for
In that
2 minutes,
condition.
my lord. If I fail to satisfy, two
No,
vehicles involved, my lord.
Mr. Datta, basic premises have to be very clear. If there is a IA before me,
Or else, Lordship, they can take notice and they can file an objection to the IA, then Lordship will hear.
no,
That also can be done. We can give notice to the other party also.
no,
They
no.
can take notice of
Then,
that
my lord,
and they
my
can
lord,
file an objection
I
and
will
then
file my
give.
objection, my lord. I will
That-
file my objection.
let that be there.
Let her furnish me the copy of the IA, my lord.
Okay.
I will furnish. I will submit my.
Okay. Heard Miss R.D. Majumdar, learned counsel for the applicant. Also, Mr. M. Datta, learned counsel for the opposite party / claimant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 365/2026, praying for staying the operation of the impugned judgment and award during the pendency of the MAC appeal number 365/2026. Stop. Learned counsel for the claimant / opposite party submits that he does not have any objection to such a prayer, provided the insurance company deposits 50% of the awarded amount and same is disbursed to the claimant, to which the learned counsel for the applicant raises objection. Stop. On this, learned counsel for the claimant / opposite party submits that he may be allowed to file a written objection against the instant interlocutory application. The prayer is allowed. Let the notice be issued to opposite party number 2. The applicant shall take steps for issuance of notice upon opposite party number 2 by speed post within 7 days from the date of this order, returnable on 25th of September. By the next date, the opposite party number 1 shall submit the written objection with a copy thereof to the learned counsel for the applicant.
Well, later directed to furnish the copy of the IMI.
That I'll be do it within 2 days, Lordship.
The applicant is directed to furnish the copy of the and memo of appeal you have received.
Already given.
Memo bill has served, but I know.
Copy of the interlocutory application along with annexures to the learned counsel for the claimant opposite party within 2 days from the date of this.
Highly obliged, Lordship. Item 8, Lordship, is an appeal that the whole amount was directed to be paid by the city bus, the dumper, whereas the city bus had caused the accident. Other than that, there are other on quantum, Lordship. Other grounds are on quantum. Lordship, here, Lordship, we have filed one IA, Lordship. IA serial number 10457 of 2026, Lordship. That has not come with the appeal, Lordship.
Let both the matter taken up together.
On Wednesday, Lordship. Otherwise, it can be admitted and then come again on Wednesday, Lordship.
Let it come together, my lord, because my lord, arising out of the same accident, several cases are pending, my lord.
Learned heard me saying R.D. Majumdar, the learned counsel for the appellant, also heard Mr. M. Datta, learned counsel for the respondent claimant. Learned counsel for the appellant has submitted that the appellant has also filed an interlocutory application, namely IA number 10457.
Serial number, not I number, I serial number 10457 of 20.
Bearing serial number 10457 for stay of impugned judgment and award. The said interlocutory application is not placed along with this record. Hence, let this matter be listed again on 20 Wednesday. 26th of August, along with the interlocutory application filed by the present appellant.
In the meantime, my lord, copy of the INA.
In the meantime, the appellant slash applicant is directed to furnish copy of the memo of appeal,
No, memo of appeal given.
No, memo
Lordship.
of appeal given.
copy of the interlocutory application to the learned counsel for the claimant respondent. Stop list accordingly.
Highly
I am
obliged.
deeply obliged.
Item 9.
May please, your lordship. Lordship, the copy of the appeal memo we have not received yet.
Mr. B.R. Das, the learned counsel for the appellant. Also, Miss, what is your name?
Be wrong.
B. Ronghanpi, the learned counsel for respondent slash claimant. Respondent number?
Your lordship, we are from Oriental Insurance Company Limited.
Respondent number 1. This appeal has been filed under section 173 of the Motor Vehicles Act. Which order you are impugning?
My lord, judgment dated 27/2012 against the MSC case number.
That has to be mentioned in the cause title. In the memo of appeal, in the cause title itself, which order you are impugning has to be mentioned. You have not mentioned this here. Impugning the judgment and award dated 27/2012. There was delay.
No, delay is condoned, my lord.
27/2012 passed by the Motor Accident Claims Tribunal Lakhimpur in MSCK number 94/2009. Stop. Let the notice be issued. Stop. Since Ms. Romhanpi has appeared for sole respondent, no formal notice need to be issued to the respondent. However, the appellant is directed to
I have served copy, my lord.
furnish copy of the memo of appeal along with annexures to the sole respondent during the course of the day. And if it is can you choose to not to make party?
No, my lord.
The owner you have not made party.
My lord, the trial court was satisfied by the opposite insurance company and all the vehicle documents was valid. So liabilities only is for insurance company. No,
But insurance company is indemnifying the owner.
no, my lord, all the documents was valid, my lord. There is no left against the documents of the vehicle.
Let the records of MAC case number 94/2009 be called for. Registry to take steps for requisitioning the records. Let this matter be listed on 25th of September.
within 25 September, TCR will not receive, I think.
After 4 weeks only,
Before.
date to be fixed. But you are at lapse. Though I have accepted the appeal, it has to be, memo of appeal has to be according to the Gauhati High Court rules and orders.
Yes.
Gauhati High Court rules. You have to mention in the cause title itself the impugned appeal. Yes, next.
My lord, there is one thing, my lord, in item number 61 in supplementary list, I have heard one word in the order said that MSCT Kamrup Metro. So if there is such word is mentioned there, then it will be again, I have to file the correction, IA for correction. So can it be corrected now?
Peter, why you are so late in
My
responding?
lord, another items is going, therefore I was not able to answer. 61.
Item number 61.
Yes, my lord.
What is the correct?
Correct MSCT tribunal not looking for, my lord. One way word was mentioned there as a MSCT Kamrup 1 metro. So that can-
61 apni loise. Okay, I'll verify.
Highly obvious.
Yes, Mr. Bhattu. Heard Mr. K.K. Bhattu, the learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been filed by the appellant insurance company impugning the judgment and award dated 7/4/2026 passed by the Motor Accident Claims Tribunal, Bongaigaon in MEC case number 92/2018. I have considered the submissions made by learned counsel for the appellant and has gone through the memo of appeal. Stop. This appeal is admitted. Stop. Let the records of MEC case number 92/2018 be called for. Stop. The registry to take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by user within 7 days from the date of this order, returnable on 25th of September, 28th of September.
Regarding IA notice will go.
Huh?
Regarding stay also notice will go.
In IA also issue notice.
Wait, please, your lordship. My lord, the only ground which I am before your lordship is that we had put some questions here during the cross-examination. We had tried to, my lord, bring on record that the deceased family or dependents had got some, my lord, financial assistance after the death because he was a, my lord, central government employee. We are not challenging the quantum as such, my lord. The tribunal had directed us nowadays, my lord, the amount has to be directly paid into the claimant's bank account.
Yes.
So, my lord, only observation and the direction from this honorable court, what we are, my lord, contemplating is that, my lord, in view of the Supreme Court decision in Virendra, where it is said that if you have applied or if you have not applied, even in that situation also an affidavit and declaration is to be given.
Declaration of?
Declaration that we have not received any ex gratia financial assistance, my lord.
Okay.
Under the
Suppose they have received ex gratia.
then that has to be deducted from the amount. Lordship, the other day I have placed one
Yes.
decision of Sarla Devi, where it says that mother is not getting any ex gratia benefit. So her share will be taken out from the compensation, and thereafter the whatever amount ex gratia has been received by the wife and the children, that has to be deducted from the estate.
Loss of dependency. Okay.
So I am ready to deposit the entire awarded amount before the Honorable Court.
Okay. Third, Mr. R.K. Batra, the learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act has been referred by the appellant insurance company, impugning the judgment and ordered award dated 30/5/2026 passed by the Motor Accident Claims Tribunal, Borpeta, in MSC case number 480/2022. Stop. I have considered the submissions made by learned counsel for the appellant and have gone through the grounds stated in memo of appeal. Stop. The appeal is admitted. Let the records of MSC case number 480/22 be called for. Stop. The registry shall take steps for requisitioning the records. Let also notice be issued to the respondents. Stop. The appellant shall take steps for issuance of notice upon the respondents by speed post. Within 7 days from the date of this order, returnable on 28th of September. Then why have you filed the IA?
My lord, stay.
Yes.
My lord, we propose to deposit the awarded amount here for this offer. Because the tribunal has directed to deposit the same into the claimant's bank account directly. So in that situation,
You may not get back the
no, my lord.
deduction.
Deduction as well as no affidavit we can obtain from the dependents matter.
Okay, okay.
Only with regard to the affidavit and a declaration that we are not receiving any ex gratia.
Okay. Heard Mr. R.K. Batra, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 458/2026, praying for stay of execution of the impugned judgment dated 30/5/2026, passed in MSC case number 480/2022 by the Motor Accident Claims Tribunal, Borpeta. Stop. The learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the applicant insurance company in the connected MAC appeal number 458/2026, and same has already been admitted by this court. He submits that in the connected appeal, one of the main grievance of the applicant insurance company is that since the deceased was working in the central government
In a border security force.
in border security forces, and therefore the dependent, and therefore his dependents, namely the present respondent / claimant, are likely to get ex gratia amount on his death. However, no affidavit to that effect has been filed by the claimants in the MAC case number 480/2022. He submits that in view of the judgment of the Apex Court in the case of National Insurance Company Limited versus Birendra and others, reported in 2020 11 SCC 356, a claimant is expected to submit an affidavit to the effect as to whether any ex gratia amount has been received by the claimants on the death of the deceased. However, nothing of that sort has been done in this case. Stop. He, however, submits that the insurance company is agreeable to deposit the entire awarded amount before the registry of this court during the pendency of the connected MAC appeal 458/2026. Stop. In view of the submissions made by learned counsel for the applicant, this interlocutory application is allowed and the execution of the judgment and award dated 30/5/2026 passed in MSC case number 480/2022 by the Motor Accident Claims Tribunal, Barpeta, is hereby stayed during the pendency of the connected MAC appeal number 458/2026, subject to deposit of the entire awarded compensation amount before the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. In view of the above order, the notice to opposite parties is hereby waived, and this interlocutory application is accordingly disposed of.
Obligement. My lord, may I pray one? My lord, in appeal memo of appeal, my lord, may I pray for serving the claimant's respondent by way of dusty also? My lord?
Additionally, stop. On request of learned counsel for the appellant in appeal, the appellant is also additionally allowed to take steps for service of notice upon respondents / claimants by dusty mode. Stop. In the event the appellant is able to serve the notice upon respondent / claimant by dusty mode, it shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
Obligement.
Lordship, decision is statutory appeal, Lordship. The fact of the case, Lordship, on 13/2/2017, there was an altercation between the owner driver of the insured vehicle by the present appellant with the victim, with the injured claimant, Lordship. So after that altercation, there was some dispute and the driver had said that we will kill you. After that, on 15th, the accident took place. And when the accident took place, the FIR was lost to the effect that he tried to kill me. So in this respect, one category PS case number 84/17 was lost, and 279, 338, 304, the attempt to murder, and 427, etc. So this is the fact of the case, but after that, another FIR of loss where no mention of any FIR, any attempt to murder is there. So our contention is that a company is liable for any accidental death, injury, etc. But when there is question of attempt to murder, there is no liability under the policy. The two vehicles are involved. Head-on collision took place. We are held liable to the to pay 50% of the awarded amount.
What happened to driver?
Lordship.
What happened to the driver?
Driver of our vehicle is alive. The victim was a passenger of the other auto. We are insurer of one Bolero vehicle. The Bolero vehicle and auto rickshaw traveled by the victim had made with an accident, collision between both the vehicles.
Who said who will kill?
Lordship.
Who said that I will kill you?
Regarding Lordship?
Who said that I will kill you?
Lordship.
Somebody said that he will kill.
Yes. Owner and driver of the insured vehicle by the present appellant.
Insured means Bolero.
Bolero.
Whom he will kill?
Claimant, which is injured person in this case. So he was passenger of that auto rickshaw, other vehicle. Claimant was passenger of that other auto rickshaw. And collision took place between both the Bolero and the auto rickshaw. And 307 is inserted in this case, attempt to murder. So this is the main ground lordship and other
Heard. Mr. A.J. Sakya, the learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been filed by the appellant insurance company impugning the judgment and award dated 31/3/2026 by the Motor Accident Claims Tribunal number 2 Hailakandi in MAC case number 89/2017. 89/2017. I have considered the submissions made by the learned counsel for the appellant and have gone through the grounds stated in the memo of appeal. Stop. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28 September. Let also records of MAC case number 89/2017 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. List accordingly.
State petition is there, Lordship.
We'll issue notice now.
Lordship, they have already initiated Bakija proceeding, Lordship. So we are going to deposit 50%, Lordship, otherwise it may cause problem. The total awarded amount is 38,73,000, Lordship. And our liability is 50%, that is 19 lakhs. And of 19 lakhs, 50% also 9,68,345 amount. But then may not be released also. They have already initiated Bakija proceeding.
Heard Mr. A.J. Sakya, the learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 460/2026, praying for stay of execution of the impugned judgment and award dated 31/3/2026, passed by the Motor Accident Claims Tribunal number 2 Hailakandi in MAC case number 89/2017. Stop. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28 September. Stop. In the meanwhile, the execution of the impugn order, impugn judgment and award shall remain stay till next date, subject to deposit of 25% of the awarded amount by the applicant insurance company before the registry of this court within 4 weeks from the date of this order. List according. Heard Mr. K.K. Datta, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act has been preferred by the applicant insurance company, impugning the judgment and award dated 4/6/2026 passed by the Motor Accident Claims Tribunal, Bongaigaon in MEC case number 221/2023. I have considered the submissions made by learned counsel for the appellant and have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the records of MEC case number 221/2023 be called for. The registry shall take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode in 7 days from the date of this order, returnable on 28 September. In IA issue notice.